The Zoom's not on this machine.
So we're waiting for the Zoom to start?
On this one?
No, for everybody else?
Yeah, that's fine.
Yeah, this one I have to invite her to panel.
Okay.
And so one technical question, so am I going to be able to see the speakers on Zoom?
You have to wait until
Okay.
they promote you as a panelist.
We'll be starting momentarily. Oh. Okay. Good evening. Welcome to the April 25, 2024 Rental Housing Committee meeting. For those joining us in person, please note that due to our hybrid environment, audio and video recordings can no longer be shared from the lectern. A request for audio or video presentation would need to be directed to mvrent@mountainview.gov by 4:30 on the meeting date. We do not have any members currently in the audience. If there were some, we would ask them if they wish to speak to complete a green speaker card. And instructions for addressing the committee virtually can be found on the posted agenda. Recently, regional and local elected and appointed bodies have been subject to disruptive, racist verbal attacks by anonymous callers during virtual public comments. The City of Mountain View is fully committed to racial, religious, and cultural equity and justice as we strive to create a welcoming, safe, and inclusive community for all. This committee welcomes respectful and non-threatening public comments regarding matters over which the committee has jurisdiction. Comments deemed otherwise pursuant to the Council Code of Conduct and the Government Code may be grounds for immediately terminating a speaker's comment period. So this meeting is called to order at 7:05, and now we're ready for roll call. Andrea?
All right, you can toggle over to your vote cast and check yourself in.
By being signed in?
So if we signed in before, is that we're already recorded?
Yeah.
Okay. So next is our consent calendar.
Sorry. All committee members are present except for Vice Chair Rosas.
Thank you. So now moving on to agenda item 3, our consent calendar. These will be approved in one motion unless any member of the committee wishes to remove an item or the item. Does anyone wish to do so? Seeing none. Public comment will occur. Okay, so now moving on. Thank you. So I now invite public comments.
There are no public comment.
Thank you. Okay. So a motion to approve the consent calendar is welcome. Oh, and it has been moved, so I'm going back to my Granicus. And seconded. And so now are we going, we can vote?
One second, sorry.
Sure.
All right, you should be able to vote.
Okay. Yes, it was.
All right, the motion was approved unanimously.
Okay, so now we will move on to agenda item 4, which is oral communications. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. We have no potential speakers in the chambers. Are there any online speakers?
No speakers online.
Okay. So that concludes oral communications. So next, we move on to our appeal hearing, item 5.1. So this is the appeal of hearing officer's decision, RE petition numbers C232400003 and C232400004. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, Rental Housing Committee members are required to disclose any communications that they have had with any of the parties to the petition or the party's representatives, and the substance of those communications since the date the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any Rental Housing Committee members have ex parte communications that need to be disclosed? Okay, seeing no's. We will now proceed to the hearing. So first is public comment. Are there any members of the public who are not parties to the petition who would like to speak? We do not have any in-person public comments. Any member of the public wishing to provide a virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen and you will be given 3 minutes.
There's no online comment.
Okay. So our next part of the appeal is moving to staff presentation.
Thank you, Chair. Are you all able to hear me?
Yes. Yes, thank you.
Fantastic. All right. So I tonight am going to spend a little time reviewing the board's role in these appeal hearings, in part because I think some of the questions that we received from the board members were a little bit beyond the scope of the appeal. And so I just want to make sure that everyone understands your role, as well as sort of what you should be considering in considering the various elements of the appeal that are, or elements of the decision that are being appealed. So just letting you know ahead of time that I will be spending a little bit more time on the RHC role section of this presentation tonight than we normally would. But the purpose of this item specifically is to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff, citing appropriate evidence in the record to support the modification. So a summary, we'll talk a little bit about the Rental Housing Committee decision process, including, as I mentioned, your role, as well as the scope of the decision and the decision process. I will also review the schedule for the appeal hearing. This is something that should be helpful to the parties as well, to let them know how long they have for their presentations. And lastly, I will do a summary of the petition, as well as the appeal and the tentative appeal decision. Next slide. Oh. Okay, so starting first with the Rental Housing Committee's options when you are hearing and deciding an appeal. So the first is the most common and what we have regularly recommended in these appeal hearings, which is to consider it a closed record, which means that you are deciding um, the appeal based on the facts in the decision written by the hearing officer. So these are all of the facts and documents to which the hearing officer had access at the time that they were making their decision. It also includes any of the arguments that were made. So, if a certain argument was not raised in the initial hearing, then it should not be considered here. Um, for a second option would be to have an open record, or this as the de novo review, in which case you would follow the formal hearing process and potentially accept new facts before deciding the appeal. And this would require you to, take testimony from the parties, introduce evidence. It would essentially be doing the entire hearing over again. And that, this is typically not recommended unless there's extenuating circumstances that the parties have demonstrated that requires a new hearing. The third is a remand, and this is sort of a hybrid. So for the most part, this would have you consider the closed record, or the record that was before the hearing officer, but you might identify issues for the hearing officer to re-examine, including potentially accepting new facts. So if you remember, a couple of weeks ago, you had a decision that had been remanded to the hearing officer for additional information and evidence to be collected regarding the water temperature and what is the appropriate standard for hot water in a residential dwelling unit. So that is one instance where you might have sort of a hybrid where part of the decision can be made based on the facts that were before the hearing officer, but part of it requires the hearing officer to conduct additional, to take additional testimony and evidence into consideration. Next slide. So the role of the Rental Housing Committee, as it relates to questions of law, is to exercise its independent judgment. This is for things such as statutory interpretation, and there is a statutory interpretation question here tonight related to whether or not the concession regulations are applicable to the instant case. So in that instance, you wouldn't look at what the hearing examiner or the hearing officer necessarily did. You would look at what the law says and determine, whether that law in fact applies here and how it applies here. For questions of fact, the Rental Housing Committee must determine whether or not each appealed element of the hearing officer decision is supported by substantial evidence. So that doesn't mean reweighing the evidence or relitigating the issues. Again, the appeal is based on the records submitted to the hearing officer, so no new evidence. And it does not mean that you have to come to the same conclusions as the hearing officer, but you do have to base your decision on the information and only on the information that was before the hearing officer at the time that they made their decision. So you can't consider new information, new facts that have taken place since the hearing, or, arguments that are not raised in the appeal or in the hearing or at the hearing. Okay, next slide. So, again, we are not recommending a de novo hearing tonight. This would require a new formal hearing, which takes a significant amount of time to prepare for the Rental Housing Committee. We believe that staff believes that the existing evidence is sufficient on which for a determination to be made on the appealed elements. And the existing record demonstrates adequate review and ample opportunities for the parties to present that relevant evidence. The decision on appeal should be based on the hearing record, and the committee should not hear or find facts in addition to those presented to the hearing officer. Okay, this is an additional area where it's important to keep in mind. So as you know, the petition or the issues that were raised in the petition by the petitioner, in this case, the tenant, are what defines the scope of the hearing officer's decision. The hearing officer is not permitted to go beyond what the tenant has raised as issues, or to, consider issues that the tenant is not requesting relief on. Similarly, appeals of the hearing officer's decision limit your review as the rental housing committee on appeal. This means that you should only look at the appealed elements of the hearing officer's decision, not other aspects of the hearing officer's decision that are not raised as issues in the landlord's appeal in this case. Next slide. So just going over a little bit more, these are sort of all of the aspects of the appeal procedures. As you know, no ex parte contact with the parties is permitted. As far as the appeal defines the issues to be decided, sorry, give me 1 second. So again, only the issues raised in the appeal are to be decided by the rental housing committee, unless this is an issue that could not have been raised by the appellant. So what that means is, for instance, if an appellant, there's a failure to maintain a habitable premises situation, the hearing officer has determined that the landlord is responsible for that condition. Let's say that it is a rat infestation, for instance. The hearing officer has determined that the rat infestation, that the landlord was responsible for the rat infestation and awarded a $200 per month rent reduction and refund for the period during which the rat infestation existed. On appeal, the landlord appeals this decision and says, no, I was not responsible for this issue for X, Y, and Z reasons that, and the hearing officer erred in making this decision. And the evidence in the record ends up being sufficient to support the hearing officer's decision. If the appellant does not raise the issue of the $200 per month and says, for instance, that that is too much, it is not up to the rental housing committee to go in and say, well, that $200 was too much, because that's not an issue that was raised by the appellant. So you really have to stick to specifically the items that are raised by an appellant in the appeal, in their appeal, and not go beyond the relief that they are requesting and making your determination. Let's see. A little bit about the substantial evidence standard. I think that's helpful as well when we say, was there sufficient or substantial evidence in the record to support the decision? What that means is that there's evidence that a reasonable mind could accept as adequate to support a conclusion. So basically, what a reasonable person would accept as enough to reach the conclusion that the hearing officer reached. If there was no substantial evidence to support the decision, then the decision was arbitrary. But if there was, then the decision should be affirmed. So that is a little bit about the substantial evidence standard. And then lastly, we'll talk about the last two. So limits on the appeal presentation. So in addition to the limitations that are on you all as to what you should consider, the appellants and the respondent, so both the landlord and the tenant, are also limited to only raising issues that were decided by the hearing officer and that were raised in the appeal. So oftentimes, there will be interactions that have happened since the time that the hearing officer has made their decision, and people will want to bring that up during the appeal hearing. That is not an appropriate topic for the appeal hearing, or for consideration on appeal. Should not be raised by the parties, but if it is raised by the parties, then your role as the rental housing committee is to ignore that information. And then lastly, again, avoiding irrelevant issues. So, I mean, for instance, let's say there's an unlawful rent petition, something like the amount of the market rent for that unit, or how much a tenant household earns, is irrelevant to the unlawful rent consideration. That's not really what that is about. It's solely about whether or not the landlord is charging more than the lawful rent, which is the base rent plus any rent increases that have been appropriately taken under the CSFRA. Okay, we can go to the next slide. So the decision process, this is just it visualized. I think we can go to the next slide. So the schedule for this appeal hearing, I will conclude my presentation, and then the appellant will have 10 minutes to argue their issues, followed by the respondent having 10 minutes to argue their issues. And then each party will have 5 minutes for a rebuttal, followed by rental housing committee questions for staff, for the appellant, for the respondent, and then finally ending with deliberations and a decision. All right. So petition summary. As you saw at the beginning, and as the chair mentioned, this appeal is actually based on 2 petitions that were consolidated because they're related to the same unit. The first is a petition for downward adjustment of rent based on unlawful rent due to incorrect calculation of base rent based on concessions, as well as the improper imposition of charges for utilities and renters insurance. Next slide. And then the second petition sought a downward adjustment of rent based on failure to maintain a habitable premises based on a glazing issue with the bathtub, shower, and sinks in the unit, a leaking faucet and toilet in the unit, and overflow of trash in the dumpsters in the common areas, and a reduction in housing services based on dumpsters regularly blocking the tenant's assigned parking spot, the unavailability of laundry facilities, the closure of the pool on the premises, and an ineffective tenant portal that only allows for one-way communication. Go to the next slide. All right, so a summary of the hearing decision. The hearing officer determined that the tenant had met her burden of proof, that the landlord had unlawfully demanded and retained unlawful rent because the landlord had not included 10 months of concessions in the calculation of the base rent, had thereafter imposed the 2021 annual general adjustment on the incorrect base rent, and had improperly began charging the tenant for utilities and associated late fees more than a year after the initiation of the tenancy. In reaching this conclusion, the hearing officer determined that the correct base rent for the unit is $2,580. I think that's supposed to be $358.33. My apologies for that. That the tenant was entitled to a rent refund of $4,686.84 for the period from September 2022 to August 2023, based on the overpayment due to the base rent issue. That the tenant was entitled to a rent refund of $1,171.71 for the period from September 2023 to December 2023, again, based on the improperly calculated base rent issue. And finally, that the tenant was entitled to a rent refund of $956.63 for the period from October 2022 to December 2023, based on the improperly charged utilities, plus $300 of associated late fees, because the tenant had refused to pay the utilities charges on the basis that they were improperly being charged. As to the habitability and reduction in services issues, the hearing officer determined that the tenant had met her burden of proof with regard to a reduction in the habitability for the period from January 2023 through December 2023, based on the condition of the shower, bathtub, and sinks in the property. That the landlord had failed to properly address the leaking toilet and faucet. The landlord had not demonstrated that the tenant was responsible for the clogged toilet, resulting in an $850 plumbing bill. That the housing services had been improperly reduced because the dumpsters on the property regularly blocked and prevented access to the tenant's assigned parking spot. And that the laundry facilities were in an unusable, unsanitary, and unavailable condition. The hearing officer determined that the tenant did not meet her burden of proof with regard to charges for renter's insurance constituting unlawful rent, a trash overflow leading to infestations in the common areas, the pool closure, as well as the tenant portal. For the habitability and housing services reduction, the hearing officer awarded a number of rent refunds and ongoing rent reductions. I won't read all of these, they're quite lengthy, but they are available in the slides, which I think you all have copies of, in case you do want to know those exact numbers. So on appeal, the landlord raised 7 issues. The first is that the hearing officer erred or abused her discretion by concluding that the landlord had not addressed the glazing issue with the bathtub, shower, and sinks, and was therefore liable to the tenant. That the hearing officer erred or abused her discretion by finding that the trash overflow of the dumpsters was a habitability issue. But the hearing officer erred or abused her discretion by finding there was a reduction in housing services due to the tenant's parking spot being blocked by the dumpsters. The hearing officer erred or abused her discretion in concluding that the landlord was required to reimburse the tenant for the remaining balance of the plumbing bill for which she had been charged. That the hearing officer erred or abused her discretion in determining that the landlord had to reimburse the tenant for the closure of the pool. The hearing officer erred or abused her discretion in reaching the conclusion that the landlord had not adequately addressed the condition or availability of the laundry facilities on the property. And finally, that the hearing officer had erred in concluding that CSFRA regulations regarding concessions were applicable to the instant case. But so the tentative appeal decision recommends affirming the hearing officer's decision in its entirety. There is sufficient evidence in the record to support the conclusion that the tenant was not required So the respondent's main contention regarding the reglazing issue was that they had attempted to address the issue, but that the petitioner had turned away their contractors and had not allowed them to enter the unit in order to complete the reglazing work. The hearing officer concluded, based on the evidence in the record, that reglazing had been completed twice before, and that the problem had reoccurred, that the tenant was not required to allow the landlord into the unit to repeat repairs that have not addressed the issue. And there is sufficient evidence or substantial evidence in the record to support this conclusion by the hearing officer. And this is also supported by the law, which states, and specifically Civil Code Section 1954A, which deals with the landlord's right to access a rental unit, and says that a landlord may enter a dwelling unit to make necessary or agreed repairs. In this case, the petitioner did not agree to the reglazing, and the respondent did not demonstrate that the reglazing was the necessary repairs. In fact, the evidence in the record demonstrated that this was probably not the necessary repair because the reglazing was not successful in the past. And in fact, replacement, as the tenant had requested, was probably the necessary repair in this case. As it relates to the trash overflow issue that was raised on appeal, the hearing officer did not award any reduction based on the trash overflow issue and concluded that the tenant had not met her burden of proof with regard to this issue because she basically had stated that it was no longer an issue at the time of the hearing and had been adequately addressed by the landlord. So it's not really clear why this issue is being raised on appeal, but the tentative appeal decision doesn't address that argument in the appeal brief because no reduction or award was provided by the hearing officer based on that issue. As it relates to a reduction in housing services for the tenant's assigned parking spot being regularly blocked, here the landlord's main contention was that the petitioner's or the tenant's assigned parking spot was only blocked on a handful of occasions, and that she anytime that the issue was reported, that the respondent promptly dispatched a team member to address the issue, and respondent eventually took steps to address the problem by hiring a private trash company. However, there's substantial evidence in the record to support a determination that the tenant's assigned parking spot was blocked on a weekly basis since essentially the time that she moved into the unit in February of 2021, that she informed the landlord on numerous occasions, at least 4 occasions of which are documented in the evidence in the record, although her testimony at the hearing was that she sent these updates weekly, that her parking spot was blocked, and that it took more than a year for the landlord to finally reach out to their waste management company to request whether or not the trash cans or dumpsters could be placed in a different or staged in a different area in order to be picked up, and the eventual hiring of a new waste management company that would not require the dumpsters to be placed in that area that would block the tenant's parking spot. That did not go into effect until December 1 of 2023, which is after the hearing took place. So at the time of the hearing, the issue still had not been resolved, despite it having been ongoing for nearly 2 years. So there's substantial evidence in the record to support the determination that there had been a reduction in housing services based on the tenant's inability to access her parking spot on at least a weekly basis. As it relates to the clogging of the toilet that led to an $850 plumbing bill, um, there's substantial evidence in the record that, um, or in essence, the landlord did not demonstrate that the tenant has caused the clogging of the toilet. And so there's substantial evidence in the record to support the hearing officer's determination that the issue was not caused by the tenant. The tenant testified that that her family did not use wipes um, and did not flush them down the toilet. She called into question whether those wipes might have belonged to a different household. Um, and she requested the documentation from the landlord demonstrating that, uh, basically the plumber's determination that it was her that caused this plumbing issue, and was never provided with that documentation outside of an invoice that merely provided the name of the service, but not the cause of the actual issue. And the landlord provided no additional evidence at the hearing other than testimony that their plumber had told them that the issue was caused by this tenant in order to support that statement. Therefore, it was reasonable for a hearing officer to find the tenant's testimony to be credible and to conclude that the tenant was not responsible for the toilet issue or the resulting plumbing bill. All right, continuing on. This is quite a long one, so please bear with me. As it relates to the pool closure issue, again, this is similar to the issue related to the dumpster overflow. The hearing officer didn't award any sort of reduction based on the pool closure and concluded that the tenant had not met her burden of proof with regard to this issue, and therefore the tentative appeal decision does not address this issue. Moving on to the laundry room. The record shows that the landlord was notified about the issues with the laundry room by several tenants. The landlord also admitted at the hearing that they have had issues maintaining the laundry room, in part due to break-ins, and there's, in conclusion, substantial evidence to support the hearing officer's conclusion that the landlord failed to provide sanitary, safe, and available laundry services to the tenants on the property, including the tenant here. Lastly, we have the issue of the rent concessions. The landlord's argument, or the appellant's argument in this case, is that the use of concessions did not become illegal until the summer of 2022, which is more than a year after the petitioner signed her lease, and that the Rental Housing Committee did not mandate retroactive adjustments based on concessions. So in essence, the respondent or the appellant claims that because the Rental Housing Committee intended the regulation to go into effect on September 1 of 2022, the regulation should not have been applied to rent concessions and increases in the instant position that were provided prior to that date. This is not the correct interpretation of these regulations, and the hearing officer's interpretation is the correct one. The regulations in Chapter 2 merely clarified the existing definition of base rent in the CSFRA, and the September 1st, 2022 date was only used to determine the amount of overpayment of rent or unlawful rent that the landlord would have to return to a tenant who filed a petition based on incorrect calculations of the base rent due to concessions. So these regulations taken together indicate that the committee intended for the amendments to apply to rent concessions that were offered for tenancies commencing on or after September 1, 2022, but also to rent concessions offered for tenancies that commenced between October 19th, 2016 and September 1, 2022, but that they chose to limit the landlord's liability for the refund of only the rent overpaid within 1 year prior to the date of the filing of the petition, which is the amount of overpayment that the hearing officer in this case awarded. So the hearing officer's determination based on the unlawful rent issue was correct. Slide. Fiscal impact. So any decision of the Rental Housing Committee on appeal, including adoption or modification of the tentative appeal decision, could potentially lead to litigation, which would have fiscal impacts. However, one of the purposes of the appeal process is to ensure that hearing decisions are legally defensible. And so the appeal process to the Rental Housing Committee reduces overall risk of legal liability and legal expenses. And so staff's recommendation is for the committee to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff citing appropriate evidence in the record. Thank you.
Thank you. So we're now ready to hear from the appellant landlord. Questions for staff come later in the process. So they're on Zoom?
They're both on Zoom.
Okay, thank you.
I think our next step is to ask them to raise their hands.
Patricia, could you go to slide 20? Thank you.
If you're speaking, so the raise hand button in Zoom for the landlord appellant.
Right,
And staff will promote you.
I'll go ahead and promote you to panelist if you can accept the invitation, please.
And you will have 10 minutes. And there will be a timer displayed on the screen.
Okay, am I also able to share my screen for a couple of items?
No, this will just be an oral presentation.
I think that part of my appeal is showing that we actually did provide, so line item 8, the plumbing bill for $850. We did in fact provide Ms. Maciel with the plumbing bill on our own on June 24th at 8:41 a.m. and we actually have proof that it was opened via email through our software system. The entire bill was actually provided to her, and the exact verbiage on the bill was removed toilet to clear the line, installed toilet back with new wax ring. Everything tested okay. Toilet had lots of wipes. This actual bill was provided to the committee. So I do think that in that instance, the plumbing bill should stand because it did state that there were a lot of wipes, and that was provided to her back in June of 22 before this even was brought up as an issue. In regards to so I'm going to go back. We are not arguing the semantics on the rent increase notices. As far as, so I'm going to skip to item 4, the NSF for $25. That is a standard fee that any landlord does charge anytime a tenant bounces their payment. That was something that Ms. Messiel did, and that is a standard charge in her lease. The bathtub and sink repairs, those were properly addressed, and I'm talking about the leaking part. Those invoices for both repairs were actually provided to the committee as well. And if I need to show proof of that, I can do that. But it seemed like when we submitted a lot of the documentation, it wasn't, I'm not sure what happened, but it seemed like that wasn't taken into consideration, because the bathroom tub and the sink leaking, both invoices were provided, as well as the plumbing bill. Those were never not provided to Ms. Messiel, as far as the plumbing bill for $850, and then to the committee for the bathtub and the sink. In regards to the reglazing, we tried to once again enter her unit to go ahead and send somebody in to make a determination on what exactly needed to be done there. The tenant has denied us access on multiple occasions. We actually asked her for a key to her unit since she changed the locks, and we gave her a timeline, and we were very nice about it. We said, hey, we will come and pick up the key. She did not get back to us until 3 to 4 weeks later, showing a continuous problem where she has continuously denied us access, regardless of the reglazing, the bathtub and the sink. This has been an ongoing issue. In regards to the garbage, the committee has stated that it was on a weekly basis, but has admitted that the tenant only showed 4 times that her car was actually not able to park in that spot. I think that's important to note. There are 52 weeks out of a year, and you guys are asking that we refund 2 years. However, she has only shown 4 times that her exact parking spot was blocked. In regards to the laundry, the facilities were always usable. We had never stated that there was ongoing issues. We stated that there was, on one occasion, an instance where somebody had broken in and damaged the coin box. That was addressed within 2 weeks. So that would only be 2 weeks of not having access to 1 washing machine, not the additional 3. So that really doesn't warrant uninhabitable laundry or unsanitable laundry facilities like the petitioner is claiming. We have had reports, yes, of somebody or our tenant stating, hey, there's an issue. However, it was handled within 2 weeks. The landlord actually purchased a new washer and a dryer for this particular property, and it seems like anything that the landlord has done really wasn't good enough for the tenants. To say that she went off and she decided to use another laundry facility and to warrant such a large concession back due to the fact that the laundry room was not sanitary, as she stated, she has provided no evidence other than word of mouth. So I think that wraps up everything I wanted to talk about at this time. Again, if I am welcome to share my screen, I can do that too, because I do think that the plumbing bills that were shared with the committee were redacted, so they were not taken into our testimony, showing that work had actually been done on the unit prior. And Ms. Messiel did receive that invoice, and we have proof that she opened up the email, and that was provided to the committee as well, and that was not taken into consideration. I'm done with my testimony.
Thank you. So next, We will have 10 minutes for the respondent tenant's address. And the respondent tenant should raise hand in Zoom. And staff will promote you to a panelist. And you will have 10 minutes. Thank you.
Hi, I'm here now. Good evening.
Yes, we can hear you.
Thank you. Thank you. If I'm addressing the board to the chair. I assume I need to respond to Ms. Amanda's presentation. Is that correct?
You will have an additional 5 minutes to respond. Is that correct?
Okay.
And now is your 10 minutes to present whatever you choose to share about the landlord appealing.
Oh, okay. So the reason I filed the appeal to begin with was because there was just a lot of things that I tried to get addressed, and just dealing with the way the process here is to submit a work order, which most of the time there's no response to. And it's just, submitting a weekly, hey, my car's blocked again, when I'm trying to head to work, I would push it over and, get my car out. But it's everything that I filed in the petition is because I did try to address the situation. And the portal that they use is always just a one-way communication. It's very rare that you get a call back or that they do actually address an issue. Just the experience, I've been here almost 2.5 years now, and I keep to myself. I try to be responsible, keep the place as best I can, and I did approach the rental housing committee because of the way my utilities were being calculated. There's only 2 of us here, and on my portal, I would see that every month they would just add on these insane utility bills. And that is what prompted me to come to the city for assistance, was that, when I added up the 3 bills, it's anywhere from $300 to $400 on water, sewer, and garbage. And to me, that's insane for 2 people. And so I tried to understand the system that they used, and it just, until somehow when I filed my petition, Miss Amanda found out, and she called me, or we emailed, I can't remember what it was exactly. And that's at the time she provided me with the actual bills so that I could look at them. And, I don't know what program they used, but when I calculated it and divided it evenly, even just dividing evenly with the units here, which is 19 units, it just didn't make any sense to me. So just a lot of unresponsiveness. And I am a responsible tenant. I pay my rent on time, every time. The $25 insufficient fund fee that Ms. Amanda referred to, that was caused because they overdrew my account at the bank when they pulled out the plumbing bill without me knowing they were going to be doing that. So that caused me a financial burden, and I had to call my bank and have them rebuke the payment, and that's what caused the NSF fee. $25 is not a huge amount of money, so that just happened to be in the petition. But that's just an example of how things, get twisted. That's the best I can describe it. Any situation that I've had to deal with Miss Amanda. One time I dealt with Brett, which is the other gentleman that works with Take On. It's always unpleasant. It always gets, it's very unprofessional. I had one conversation with the owner, Miss Ella, and, she speaks nicely. She says she wants to do things, but things just never happened. And got fed up with it, and that's why I went to the city to find some support with this. I just want to live in peace and be as comfortable as I can afford to be. So I appreciate the time everybody here is allowing me. So that's all I have to say. Thank you.
Thank you. So now our next step is to hear again from the landlord, and you will have 5 minutes to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating information already shared. So again, raise hand.
All right, go ahead and begin whenever you're ready.
The petitioner didn't really make any comments as far that I have to address. As far as the utilities go, she was always responsible for utilities per her lease agreement. She never asked for any of the calculations. However, when she was served the notice that utilities were going into effect, there was a huge document. We actually had to tape all of these to the doors. And she received it. We have confirmation of it. We have pictures of it. We actually started taking pictures of the notices that have been posted to her door because it just, more often than not, she says that she doesn't receive something even despite us taking pictures. She also brought up that we took out the money. We have no control over what gets withdrawn out of the account. That is a security feature within AppFolio, our software system. And I think any property management software actually has the same security feature where landlords are not allowed to just take money out of their tenants' accounts. If they were able to do that, I think you guys would be seeing a lot more of these cases. That was a payment submitted on her behalf by her. And I also have documentation that will show that. Our system is very efficient. We have been using it for years. Myself, I've been using it for 13 years. And anytime a payment is processed, it is by the tenant. No landlord has any authority, no property manager, no anyone to withdraw funds out of a tenant's account without their authorization. So I think those are the two things that I kind of want to go over, and I am done. Thank you.
Thank you. And next, we will move to the respondent tenant, and you will have 5 minutes to rebut any statements made by the appellant, the landlord. And please limit your comments to rebuttal rather than repeating information already presented. So if you could raise hand again.
All right, thank you. Go ahead and begin whenever you're ready.
Okay, thank you. So there is, I did submit my bank statements that show where the $850 were tacked on to my rent amount and withdrawn along with my rent at that time. Some of the notes I took just from what she addressed earlier, what Ms. Amanda addressed earlier, was that she submitted plumbing bills. My sink is still leaking, and so is my toilet. That has not been repaired. There was a plumber that came in to look at the problem shortly after I had put in the second maintenance request or work order, which had been, I don't know if a month or two, that I said, hey, you know, I hate listening to water leaking all night, because this is a Jack and Jill bathroom. I think that's what they're called, where there's 2 bedrooms and we share the bathroom. So like literally I had to move my bed because I couldn't sleep because of water running. So when the plumber came, he said that the toilet and the sink were too old and he couldn't he wouldn't be able to find parts. So he was gonna let my landlord know that we needed to replace the sink and the toilet. And never again did any plumber come out here, and it wasn't addressed. And since I filed the petition, I've been trying to limit my interaction with the with Taycon, who's the managing company. So she also states that I changed the locks. I would not invest in changing locks at a place that does not belong to me, because she makes this accusation because they can't find the keys to my apartment. That is not my fault. I sent in a work order since they insist I need to communicate through the portal. I sent a work order. I said, look, I have a set of keys because before when we first moved in, it was myself and 2 daughters. One of them moved out. So I said, I have an extra set of keys. I'm going to keep it here. Pick it up anytime you want. Let me know. Never heard back. So I just wanted to be noted, I did not change the locks to this apartment. It's the same lock, and I have requested via work order for them to pick up a key. I don't know that I trust, them coming into my apartment when I'm not here, but it is what it is if that's the law. So yeah, again, the portal is usually a one-sided communication tool. Miss Amanda states that there are 3 washers and that only one was broken. That is incorrect. There's 2 washers and one has never worked. And the one that Miss Amanda claims that the owner purchased for this apartment complex, it doesn't work. I don't understand how it's new because it's sitting there. I have pictures. I didn't know that I should submit more stuff. But there's still, as of today, there is 1 washer that works. And this is a 19-unit complex. I think that's everything that I jotted down. Oh, I did want to note that the trash cans have not been moved. The trash cans continue to be picked up behind my parking spot. Now they don't stay out all day, where when I come back from work, they're put back. So to me, that solution works. That is all I asked, that when I came home from work or when I'm trying to pull out of my parking spot, the trash cans weren't there. These are big 6-yard waste containers that, a couple times I moved and, I hurt my back. I don't want to continue to do that. So that resolution, even though the description is inaccurate, it's the solution is acceptable to me. So I do appreciate that being taken care of. That's it. Thank you so much.
Thank you. So moving through our appeal process, we have 2 steps consecutive. First will be questions for staff, and then following that will be questions for either the landlord or tenant. So Rental Housing Committee members, who has questions for staff? And just a minute while I get, okay. Committee Member Cox.
Thank you. I just want to ask 2 questions about the presentation that Nazanin gave so that I have clarity on everything that she told us tonight. It was a lot, and I appreciate your taking the time to go into the details. But one question I have is about, the idea of and I'm not saying it happened tonight, but let's say the appellant or the respondent had presented what seemed to be new evidence, either by stating it explicitly by saying something like, well, you may not know this, but, and then saying something, okay? Or, just saying something that I don't remember reading, in the information that you sent to me. So it's my understanding from listening to you that, should new evidence be presented, we are to disregard it because we are to base our decision on the hearing officer's report and the evidence in that. Do I have that right?
That's correct. Yeah.
Okay. And then the second question is, if somebody raises a point in their testimony and I can't tell because I don't have 100% photographic memory of whether or not that was in the evidence that was presented to us from the hearing officer, it's okay for me to ask if it was. Is that right?
Yes, you can always
good.
clarify.
Okay.
Yeah.
All right, that takes care of my general questions. Let me just ask then just a few questions about this particular case to staff to make sure that I have all the points clear in my mind. What I remember, there was some discussion in here about the plumbing issue. And what I remember reading is, and they said that that had to do about wipes being flushed down the toilet and then causing a plumbing issue. And what I remember from reading in the testimony was that the key reason that this part of the appeal was dismissed by the person reviewing the hearing officer's report was that the landlord, it was the landlord's responsibility to provide some proof that this was caused by the tenant, and that proof wasn't provided. And therefore, the staff person or whatever writing up, the tentative appeal, agreed with the hearing officer's decision. Do I have that right?
That's correct.
Okay. And the next question has to do with the laundry. I believe that it said in the report that the decision in the tentative decision on the appeal was based not solely on the testimony of the tenant, but also other external evidence from other tenants who had also complained about the state of the laundry. Is that right?
Yes, that's
Okay.
correct.
All right.
That there was actually a tenant who testified on behalf of the petitioner in this case, who was a neighbor who had recently moved out, who testified essentially to the same things that the petitioner had testified to, and the owner, Miss Levin, I believe is her name, also testified that she had received reports about the laundry room from a number of other tenants. So that was admitted by the landlord at the hearing.
And then my only other question on that item is, if you can answer it, is that, was there evidence there that went beyond, the idea simply that somebody had at one occasion vandalized the unit and then it was fixed 2 weeks later? There were other things at issue with the laundry. Is that right?
That's correct.
Okay.
Both tenants testified that the condition of the laundry room was disgusting, is the exact wording that they both used, and that it was, that made it extremely difficult for that to be used. They also testified as to the fact that, that one machine broke and was replaced by another machine that broke shortly thereafter. The landlord themselves admitted that there was at least 2 break-ins into the laundry room, and stated that they'd had trouble, repeatedly had trouble with keeping individuals who they believe are unhoused out of the laundry facility. And so there was quite a bit of information, and the landlord stated ultimately that they had hired a cleaning service, the Stannis cleaning service, because of the poor condition of the laundry room.
Okay. And then one last question. I mean, this has to do with the portal. It sounds like, was there any evidence about whether or not there was an alternate means of being able to bring issues to the landlord except through the portal?
So I'm not going to answer that question. It's not raised on appeal by either party. Neither the landlord nor the tenant
I've got it.
raised that. Yep.
It's okay because it's not on appeal, so then it's not material to the hearing tonight. So I appreciate that. Okay. Thank you. You've answered my questions. Thank you for taking the time to do that.
Committee Member Balch.
Yes, thank you. I have 3 questions for staff, somewhat building on Committee Member Cox. So the first one is that it seemed to me that in reading the the appeal as well as in the testimony, that there was substantial new information that was not necessarily brought up to the hearing officer in the appeal, kind of like Committee Member Cox is saying, I don't have a memory to be able to, in real time, do a text comparison. So can staff just kind of validate or invalidate my perception that there was a lot of information that feels new?
That's correct. Quite a bit of the information, including, I would say probably the first 3 entire paragraphs of the appeal brief, are new information that's unrelated to anything that was brought up at the hearing. It relates to this lock, the changing of the locks and the access to the apartment. Other than as it relates to the one time that the landlord and the tenant agreed that the tenant refused entry for the reglazing, that issue is not relevant on appeal. There were also additional arguments that were brought up within each of the appealed elements that were constituted new evidence. If you all have questions about what that is, feel free to ask me, and I can point out to you which parts of it were in the hearing record and which parts were not.
Thank you. Okay, understood. My second question then is, I heard a lot of statements that I would categorize, if I was in a hearing officer capacity, which I am not, I would be trying to weigh evidence, the veracity of evidence, and trying to validate for myself, if I was in a hearing officer capacity, which I'm not, what I believe to be true or not true, because I heard very different accounts of very basic similar information. And so I just want to verify that in our role on the RHC, we are not here to weigh the veracity of evidence. We're not here to determine if there is a color of a car and one person says it's blue, the other one says it's red, I don't get to decide, was it blue or red? I'm going to go with the hearing officer's statement, was it blue or red? Is that true?
I mean, I don't know, Karen, do you have a good way of explaining? You certainly don't have to come to the same conclusion as the hearing officer in weighing the evidence.
But so I just want to be clear. So at the hearing, the parties testified and presented evidence. What you heard tonight was summaries of arguments.
Yes.
So the hearing officer would have weighed the veracity of the testimony that was given. As Naz said, you don't have to come to the same conclusion, but you have to base your conclusion based on the record. So you would have to point to something in the hearing that would make you change the decision of the hearing officer based on the veracity of anybody who testified. So we'd have to have very specific information from the record for that.
Thank you. Okay, understood. Okay, great. Thank you. So then my third and last question then is that based on what we heard in the testimonies over the last few minutes, if there is just a fundamental disagreement between the parties on what actually happened, and regardless of what the RHC decides, and that disagreement persists, is it the case then that ultimately the party who disagrees could choose to go to the courts and to appeal at a small claims court or whatever type of court, but we're not the last stop? If they fundamentally think that the car is blue and the hearing officer said it's red and we validate it's red, then they can go to court to prove that it's blue.
That's correct. So either party, if they're unhappy with the decision you ultimately make, can file what's called a writ petition with the Superior Court to ask the court to review that decision. Those decisions are generally based on the record as well. It's not a new evidentiary hearing. The court would look at the record that was presented.
So just to make sure I understand that, so in this process, there is actually no legal option to relitigate this from scratch or kind of to bring in new evidence outside of the purview of the RHC?
The only option would be if you were to remand the decision back to the hearing officer to reopen the hearing for some particular reason.
But that's our decision.
That is
one
your
of-
decision.
One of the parties cannot appeal going back all the way back to the basic facts.
No. I mean, they were given opportunity to present their evidence at the hearing. Often the hearing officers will leave the record open for them to submit additional evidence, but that is their opportunity to present their case and their full evidence at that level.
Okay, thank you.
Okay. I think the plumbing and the wipes are still have my attention on this. And so as far as, if there is a tenant-caused repair or a need for a repair, then would giving a bill to the tenant be appropriate? Is that, is there state law on that, or?
Tenants are responsible for damage that they cause to the unit beyond normal wear and tear. But it is an issue of who actually caused the damage. And frankly, sometimes with plumbing, it's often hard to tell because the damage could be an accumulation over many years. So before the tenant moved in, et cetera.
And in the hearing officer's write-up, our takeaway from that is that she did not have evidence that they felt proved that the tenant had caused the wipes in the toilet.
That's correct. After weighing all the evidence submitted at the hearing officer determined that there was not evidence that it was caused by the tenant.
And so then the landlord, during that hearing process, had the burden to prove not the possibility that it was caused by the tenant, but the proof or the, substantial evidence that it was caused by the tenant.
So the petition was brought by the tenant. The tenant has to prove their case. The landlord didn't rebut the tenant's evidence that it wasn't caused by them. So weighing all the evidence, the hearing officer determined that it was not caused by the tenant.
Thank you. Are there other questions for staff? And are we back to our committee member Balch being our alternate and committee member Vice Chair Rosas being our voting member? Thank you. And so then next, we can ask questions if we have any for the landlord or the tenant. Do we have questions we'd like to ask the landlord or the tenant? Just give me a moment here to look at my notes. I guess to staff, is it, I guess another place where I'm curious, where I feel like we've heard different testimony, and I'm wondering if it matters at all or not, is around, was the 800 bill for the plumbing out of the, deducted from the tenant's checking account, if that was a surprise or was known that that was going to be deducted. Is that relevant to the appeal?
No, I don't think that was raised on the appeal. But can you?
No, just that the tenant was not entitled to a refund of the remainder of the amount that, so the landlord did ultimately refund $450 to the tenant. And then the hearing officer determined that the additional $400 that was remaining should also be refunded. But as to whether or not it was, the automatically taken out of the account or not, that's not really, it doesn't matter at this point to the appeal.
Thank you. I do not have questions for the landlord or the tenant. Does anyone else?
Staff would like to mention that and this was provided to you in your record, that the hearing officer provided a post-hearing order requesting documentation from the respondent for a variety of things, including documentation and proof of any communication between the property owner and the tenant for trash, laundry facilities, other items, etc. So they were provided an opportunity to provide that information at that time.
Committee Member Rosa?
It's not, so my question is to staff. In all fairness, since I wasn't here and hear all the testimony from both parties, I did read what you sent us, but I was not here. I was not here in time to hear the two parties, so I don't feel that I can give a fair vote. So is it possible for me to, like, in this case, or do I have to vote? Or can I revert it back to the alternate?
So if you don't feel like you can vote in this case, I would suggest that you leave the dais in the room, and that would allow the alternate to participate in this vote.
Okay, and then I can come back once?
Yes.
Okay,
Yes.
then I will do that, because I don't feel it's fair to everyone.
I would like to ask one question to the tenant. Are they available? So my question is, because now, we heard about the impact of where the dumpster used to be located, and we're happy to hear it was resolved, but that you would have to move the dumpster yourself. And I would just like to ask how often. Was it most weeks or every week?
It was mostly every week. Mostly every week.
Thank you.
Thank you.
So
If I might, Chair, on that question, this is not cited in the tentative appeal decision, but there was also testimony, as I mentioned, from the tenant's witness, who was another tenant on their property, and she did testify that she quite frequently texted the tenant to let her know in the mornings that, oh, the trash can is blocking your spot again. Sort of good luck getting out today. So
thank you for pointing that out.
There was, corroborating evidence as to the weekly occurrence of this.
Thank you. Okay, I think we are ready now for the committee to deliberate on this, and it would be appropriate for a motion to adopt the tentative decision, and after that motion, if we can have further discussion, our feelings on, or our beliefs on that. Committee Member Cox?
Okay, I'm in favor of adopting the staff recommendation on the appeal decision.
So we'll still have discussion, are you
Yeah,
ready
but
to move that?
I'm not trying to move that right now. I'm just telling you my opinion, and then other people can do that, and then we can take a motion. But I mean, that's my view, and I guess I could move it if, what's the procedural thing?
My script says, go ahead, please.
You can move it, and there can be a second and then discussion of the motion, or the chair can allow discussion
Okay, well,
before
then
there's
I'll
a
move
motion.
it because, and let me give you my rationale, and, we'll see, we can take a vote. But I just want everybody to have the chance to speak. So, I mean, here's the thing. On each of the points, I think that we got a good clarification by talking to staff and listening to the testimony. That I didn't hear anything in the testimony that contradicted what was in the tentative appeal decision and in the hearing officer's report. some of the arguments made, I can see why, I mean, they gave me a chance to consider some of it. I mean, like the landlord brought up the idea that, well, the tenant only showed like evidence with pictures maybe of only 4 times when this happened. But quite honestly, I think that, 4 times is pretty good evidence of a consistent pattern here. And so, I think it's good enough for me, okay? And I appreciate the clarification on the laundry issue because, I would have felt differently if, like it was one time somebody broke in and the landlord fixed it immediately. There are some things that are just beyond somebody's control, but we have the additional external testimony on this. And, it's just the fact that they went and had to change cleaning services, is kind of an acknowledgement that there was a problem beyond something that was not within their control. So there's that. And, again, there was a lot of talk about, the portal and everything like that, but since it's not part of the appeal, it turns out not to be, a material to what it is we're talking about tonight. But in any case, yeah, those are my justifications for making this motion. And, I would just like to say, having heard a number of these over the last term, I don't know if staff's ever done this, but I think it'd be great to have a workshop on how to put a good case together for one of these things, because I hear so much of, what's new evidence, of stuff that's not material to the case. And I get the feeling that, it's because you don't have to pay for legal representation and it's immediately available. People get the impression that they can come in with, just not really good, not really well prepared to make their case. And I want people to be able to make the best case they can. And I think staff is in a great place to help them with that. So that's my opinion on that. Thank you.
Speaker Q, Committee Member Balch.
Yes, thank you. This is a really interesting case because taken on their own, each of the parties independently sounds credible. But there is basic disagreement that I hear on relatively simple facts. Each side is mostly credible, but there are some things which don't seem to make sense to me. I'll give one example on each side. So the access issue, that's a fundamental requirement of a lease. And so if a tenant is not giving access, is changing locks, whether it's a 3-day notice to quit or something else, there are specific ways to address fundamental lease violations. And then this issue of the debiting without permission from a bank account. I'm not familiar with a process by which a third party goes into someone's account unless a automatic recurring transfer is set up. There is more to be said about that, which comes to the point of the veracity of evidence, which is clearly out of the scope of this committee. So as much as I or we may want to go deep into this, that's simply not our function. We can't do that. I think when it comes to the points about the disagreements on vandalism versus hygiene, glazing, it works, it doesn't work, the clogging is which unit's responsibility, those are not things that we're able to decide here. And so ultimately then, the only remedy would be going to the court to the extent that that's available under this charter amendment. So I also am supportive of the hearing officer because what we've seen, based on what the hearing officer weighed, to me that is plausible. And all these other issues around veracity and what really happened, that's simply not something we're set up to be able to decide here. Thank you.
Committee Member Brown.
I'd like to say I support Robert's proposal that we have a workshop or some other way to try to help create better cases. I think that the appeal process is very valuable and important, and I would like it to be well thought out and formatted before it gets to staff and us. So, +1.
Although in some ways, some of what we're hearing tonight is better presentation of evidence, more complete presentation of evidence in the hearing itself for the petition, would be the ideal place for, the more complete presentation. So, do we have other comments on this? Okay, I think we're ready to vote.
The motion was initiated by Committee Member Cox and seconded by Committee Member Balch. The motion passed unanimously. Thank you.
Thank you.
Ms. Tiedemann or Ms. Delehe, can you please, just for the sake of the appellant respondent and the appellant landlord and the respondent tenant, just state what that means, that the motion passes unanimously?
Is that to me?
No, that's to us.
No, I
It's to
believe
legal
it's
counsel.
legal counsel. Yeah, I can go ahead and I will just actually read the decision aspect of the tentative appeal decision, which was affirmed in its entirety, which means that it was accepted. And this is the decision of the Rental Housing Committee. And let me go ahead and read that entire determination. So the Rental Housing Committee denies the landlord's appeal in its entirety and affirms the hearing officer's decision in its entirety. This means that the petitioner is entitled to a downward adjustment in rent to the correctly calculated base rent of $2,358.53 per month. That is the legal base rent for the unit. The petitioner will be entitled to a rent refund of $4,686.84 for the 12-month period from September 2022 to August 2023, a rent refund of $1,171.71 for the 3-month period after she filed her petition, a rent refund of $390.50 per month for any months after December 2023 for which she has paid or does pay more than the lawful base rent of $2,358.33. The petitioner is also entitled to a rent refund in the amount of $956.63 for the period from October 2022 through the date of the hearing, plus a refund of any utility charges paid to the respondent through the time that the decision of the Rental Housing Committee becomes final. Respondent shall stop charging the petitioner utilities charges upon this decision becoming final. The petitioner is entitled to a refund of $25 for an improperly charged non-sufficient funds fee, a refund of $300 in improperly charged late fees related to utilities charges, and a refund of any other late fees associated with the non-payment of utilities charges. The respondent is required, or the landlord is required, to correct the rent ledger and refund these fees. The petitioner is entitled to a rent refund of $1,200 for the 12-month period from January 2023 through December 2023, a rent refund of $100 per month for any month since January 2024 that the bathtub, shower, and sinks remain in disrepair, and an ongoing rent reduction of $100 per month for every month thereafter that until the peeling bathtub, shower, and sinks are replaced. The sinks and bathtub must be replaced within 30 days after this decision becoming final. The petitioner is entitled to a rent refund of $200 for the eight-month period from May 1, 2023 through December 2023, a rent refund of $25 per month for any month since January 2024 that the toilet and sinks have continued leaking, and an ongoing rent reduction of $25 per month for every month hereafter that the toilet and sinks are not replaced. Sorry, this one's a long one, still going. The petitioner is entitled to a rent refund of $3,500 for the 35-month period from February 2021 through December 2023, a rent refund of $100 per month for any month since January 2024 that the petitioner's access to her parking spot has been obstructed by the dumpsters, and an ongoing rent reduction of $100 until such time that the petitioner is provided with proper access to her assigned parking spot. The petitioner is entitled to a refund or a credit of $400 for the remaining balance of the plumbing bill that she was charged. And lastly, the petitioner is entitled to a refund of $950 for the 19-month period from June 2022 through December 2023, an ongoing rent refund of $50 per month for every month since January 24 that the laundry facilities have been inaccessible, unsafe, or unsanitary, and an ongoing rent reduction of $50 per month until fully accessible, clean, and safe laundry facilities are provided. And just a reminder that to the parties that if there is disagreement about whether the landlord has complied with the requirements in this decision, and whether in regard to replacements, repairs, reinstatement of housing services, or the payment of any of the required refunds, then the compliance hearing process is available to the parties.
Thank you. I think now we're ready to conclude the appeal and move on to item 6.1. Options for determining the value of rent reductions related to habitability, maintenance, and housing services petitions. Public comment will occur after the presentation and committee questions. And if we do not have anyone in person, so I think we're ready to begin with the staff presentation.
Good evening, committee members. Thank you, Chair Keating. Item 6.1 is a study session for options for determining the value of rent reductions related to habitability, maintenance, and housing services petitions. And please bear with me, I'm a little bit under the weather this evening. So a little background information for you. Residents of rent-stabilized units under the CSFRA and the MHRSO may file petitions for downward adjustment of rent for three main reasons: unlawful rent, failure to maintain habitable premise and/or reduction in housing services, and undue tenant hardship. This evening, we are looking at the second reason, failure to maintain habitable premise and/or reduction in housing services. Petitions for failure to maintain habitable premise or reduction in housing services can include topics like the living conditions in question, evidence that the tenant has first attempted to notify the landlord of a condition, the landlord has been given the opportunity to correct conditions but did not do so, and a tenant's estimate of the monetary impact that the condition has had on the ability of the tenant to fully enjoy their rental unit. So what does this process look like in the hearing and decision process itself? The hearing officer evaluates the petition, all of the documentation and evidence provided by both parties, and applies the applicable provisions of the CSFRA and the MHRSO, as well as what was presented, any testimony given at the hearing, and makes a finding regarding any reduction in rent and a refund, if any, that is due to the tenant. The hearing officer then issues a formal, legally binding decision with a determination regarding if a downward rent adjustment is required, and if so, the amount of the rent reduction. Either the landlord or the tenant can file an appeal with the RHC should either party dispute the outcome of the decision. And we have seen both parties appeal habitability and maintenance petition decisions. From November 2017, when we first started accepting petitions, through February of 2024, 216 petitions in total from landlords and tenants were filed with the city. 66 of those petitions, 31%, were filed by tenants for claims regarding habitability and or housing service reductions. 44 have final decisions. Of those 44, 25 of the final decisions were in favor of the petitioner, and 15 of those decisions that are now final were appealed to the RHC by landlords. At the direction of the RHC, staff analyzed the following issues. Please pardon me for one moment. The main point of this evening's study session is to provide the Rental Housing Committee with an opportunity to review potential policy options related to the valuation of issues presented in habitability and service reduction petitions. And for that, we took a look at 3 areas to assist with evaluating potential policy options for the committee. At the direction of staff, we are presenting this study session and analyzed the following areas: the existing methodology currently used by hearing officers to determine the value of rent reductions, case studies of methodologies, policies, and regulations of select comparable rent stabilization jurisdictions, as well as input from hearing officers. So under the CSFRA and MHRSO, hearing officers have authority and discretion in determining the amount of the rent reduction in the decision. In the regulations, it states the following information for hearing officers to consider for rent decrease petitions: the amount of rent adjustment attributable to each failure to maintain the habitable premise, the decrease in housing services or demand for or retention of unlawful rent claimed in a petition, the basis for each rent adjustment ordered, the duration of the adjustment, the amount of any rent allowed to be restored upon the correction of each condition, and a requirement that the landlord provide at least 30 days notice to any affected tenants prior to the restoration of rent. And they go into further detail that also outlines some other information that must be provided in the decision. But it does not include any more detailed methodologies. Now we will look at policies in comparable jurisdictions. So 14 jurisdictions were evaluated. 6 are like Mountain View, as you can see here, and have neither detailed methodologies or valuation guidelines. 8 have detailed rent decrease methodologies, and 3 have detailed rent decrease methodologies and valuation guidelines. And we'll talk a little bit more about what those mean, but essentially, the jurisdictions that have detailed rent decrease methodologies provide more information about what hearing officers can consider when making their determination. And then on top of that, 3 jurisdictions also have a valuation guideline or schedule that provides monetary assessment of potential issues. All jurisdictions that allow for hearing officer discretion on whether to apply the calculation methodologies or the valuation guidelines. And that is also required by the CSFRA and the MHRSO. So we're going to look at these kind of in 2 buckets: rent decrease methodologies and then the less used valuation guidelines. So first we'll look at the rent decrease methodologies. Regulations vary widely in content and detail around methodology, and there are no industry standards that are common across jurisdictions. Considerations or methodologies include impact of violation or issue on tenants' health and well-being, the impact of violation or issue on the tenant's use and benefit from the unit, the size or impact of a decrease in space or services, the seriousness of the violation, the lack of responsiveness to correcting issues or the violation, and compliance with California civil codes. And potential calculation methodologies that are included in some jurisdictions include the percent of impairment of the tenant's use of and benefit from the unit, the percent loss of square footage affected by violation, reasonable monthly replacement costs for the item or service, and a minimum percentage of award. So there are a few jurisdictions that state that no matter what, regardless of how an award is determined, it cannot be less than 10% of the rent. And in some jurisdictions, if there's a repeated violation or the property owner has shown that they have not been willing to timely address the issue, the award minimum is actually 20%. And now we'll look at the second bucket, the valuation guidelines. These are only ever used in addition to the more detailed methodologies. I want to note that guidelines vary widely in violation area and monetary range. There is no industry standard that is common across jurisdictions. The 3 jurisdictions that have the guidelines are in addition to the detailed methodologies. No jurisdiction has these valuation guidelines alone. They don't stand alone in any jurisdiction. And for all 3 jurisdictions, the valuation guidelines became effective in the 1980s, and this could suggest that this is a practice that is not commonly adopted by jurisdictions, particularly in jurisdictions with newer rent stabilization laws. I also want to mention here that valuation guidelines are often of quite a range, a monetary range. So for example, you might see a range, and I don't have the exact numbers memorized, excuse me, but for one jurisdiction, I believe plumbing assessments of valuation were between $17 per month and $455 per month. So that kind of gives an example of what you see with these guidelines. And I'm happy to pull up some of the attachments that we provided that show the actual regulations from these jurisdictions if you want to take a look at what the schedules look like, guideline schedules look like in some jurisdictions. We also received input from hearing officers. They expressed that they prefer access to prior decisions and petitions with similar circumstances. We've provided this to them in a repository for them to use that really has every single decision that has been decided upon, and they can access that based on what kind of petition they are currently hearing, so that they can have some insight into what prior hearing officers have done. They've also stated that additional methodological regulations may be helpful to provide best practices, such as ways to determine the percentage of rent or the percentage of usable space affected by violation. They also provided insight into hearing officer authority and discretion in the CSFRA, the MHRSO, and the accompanying regulations. And they shared that in other jurisdictions with valuation guidelines, the range of reduction can vary widely, which may diminish the usefulness of guidelines in helping to determine the appropriate reduction. And they expressed concern that valuation guidelines may expose decisions to additional legal risks. It's difficult to include every potential violation, and property owners may be able to use this as a defense against not addressing potential habitability issues. So given that background information, there are four policy options up for consideration. The first one is to maintain current practice, like we see with 6 other jurisdictions that we reviewed. The RHC could consider maintaining the current practice with no change to the regulations. Hearing officers continue to adjudicate petitions utilizing the same practices and as specified in the CSFRA and MHRSO and the accompanying regulations. They'll continue to provide analysis, detailed in decisions and accompanying award schedules, describe the methodology and reasoning behind the award based on a variety of factors, including the evidence, including the percentage of the space affected by the violation and the evidence provided by the parties. Under this option, staff will continue to analyze past decisions as requested by hearing officers. And that was actually, my apologies, left out of this slide. One of the other things that the hearing officers stated that they're interested in is having an analysis provided by staff of what options and methodologies had been used to determine the decision outcomes for petitions related to habitability and housing service reductions. And staff has started that work. We started it this spring. Option 2, the RHC could consider adopting regulations that offer more detailed methodologies for hearing officers to consider when determining habitability and housing services rent reduction awards. Information could include areas of consideration when determining awards and examples for calculations. Under this option, staff will continue to analyze past decisions as requested by hearing officers. And additional research and draft regulations would not be brought back to the RHC until early to mid 2025, Q3 or Q4 of the 2024-25 fiscal year. We'll go over the benefits and the challenges of these as well. In option 3, the RHC could consider adopting regulations that include valuation guidelines, listing violations and potential ranges of monetary awards. In option 2, and this would only be in addition to option 2, which specifies our methodologies. Additional research and draft regulations would not be brought back to the RHC again until early to mid 2025. And I'm going to just give a quick break in sharing the slides so that I can bring up the challenges and benefits as outlined in the memo. Before I do that, I also want to share a little bit more insight on the wide variety of violations and what you see in the valuation guidelines that we spoke of in the other jurisdictions. The 3 jurisdictions that have valuation guidelines, the City of Los Angeles, Santa Monica, and West Hollywood. The City of Los Angeles only states 20 specified violations in their valuation guidelines. The City of Santa Monica has 37 specified violations and also 15 additional specified violations for construction impact related petitions. And then West Hollywood has 77 specified violations. As mentioned previously, ranges of the award often vary greatly. For example, the City of Santa Monica's valuation guideline, I got really close here. In remembering, it is a range of $18 to $455 per month, and then West Hollywood for the same type of violation has a range of $5 to $277 per month. And now when we're looking at the options, option 1, again, this is maintaining our current practices. The benefit of this is that hearing officer decisions provide detailed information on the considerations and methodologies used to assess and determine associated monetary awards. No legal challenges have been raised for decisions utilizing current practices since the division began accepting petitions in November of 2017. The challenge associated with this option is that it does not provide additional tools for hearing officers on what to consider when determining reductions in rent for this type of petition. Additionally, maintaining the status quo does not improve the public's understanding of how reductions in rent are determined or how to more effectively complete the evaluation portion of the petition form. This is one thing that these are 2 areas that we have heard feedback from that could be potentially improved. For option 2, which is performing additional research into and providing draft regulations for RHC consideration that further specify methodologies and areas of consideration for determining rent decreases for habitability and/or housing services petitions. If you were to adopt additional detailed methodologies, The benefit of this would be that drafting regulations with more specific methodologies and areas of consideration would provide additional insights and clarification for hearing officers on what to consider when determining awards for this type of petition. Additionally, it would improve the public's understanding of how reductions in rent may be determined and may also assist petitioners in more effectively completing the valuation portion of the petition form. Challenges with this approach include that because there are no industry standard that appears to exist for this type of regulation, determining what methodologies and areas of consideration should be included in regulations may be time consuming and may be challenge due to staff capacity. Due to the challenges associated with drafting regulations for this option and staff workload, additional research and draft regulations would not be brought back to the RHC, as we mentioned before, until early to mid 2025. For option 3, which would only be included for consideration in addition to option 2, staff would perform additional research into and provide draft regulations for RHC consideration for valuation guidelines. The benefit of this is that valuation guidelines may help the public more easily understand potential petition outcomes. However, there are challenges associated with this. The lack of standardization for valuation guidelines means that determining what violations should be included in the guidelines, as well as the valuation ranges themselves, will be time-consuming and challenging for staff. Due to the challenges associated with drafting regulations for this option and staff workload, as mentioned before, additional research and draft regulations would not be brought back to the RHC until early to mid 2025. Additionally, while appearing to clarify awards, the wide variations and necessary ranges of the awards may limit the efficacy of valuation guidelines. These guidelines could also lead parties to the petition to have unreasonable expectations related to the outcome and may increase appeals if the hearing officer makes an award that does not adhere to the guidelines. Monetary valuations also have differing impacts depending upon the rent and unit size, so may not accurately reflect the situation at issue in the petition. Finally, as stated above, this methodology could increase legal risk and potentially result in increased litigation. And I just want to clarify for the committee that these regulations, both the more detailed methodologies and the valuation guidelines, are not restrictive to the hearing officer. The hearing officer can consider utilizing them, but ultimately has discretion and authority as provided under the CSFRA and the MHRSO, and that is also spelled out in the staff report. And then finally, the RHC could provide other direction on this policy topic. So the recommendation that we have is to provide input on potential policy options for the valuation of habitability, maintenance, and housing services decision rent reductions. And I do want to mention really quickly the fiscal impact associated with this. While this study session has no fiscal impact to the RHC, the valuation guidelines and the methodologies, the research into those and the drafting of regulations due to staff and legal counsel time may have an impact on the RHC budget. And that concludes staff's presentation on this topic. Happy to take any questions.
Okay, let me get back to Granicus so I can see who wants to ask questions. Committee Member Ma.
Thank you, Chair. My first question is to staff. So on slide 44, staff will continue to analyze past decisions. What is in the analysis that staff does? Is it more of a summary of what happened or something else?
So this is something that staff has just started based on hearing officer requests. And what we're doing is taking a look at the methodologies used for the decision outcomes and providing them for the hearing officers so that they know that, this decision was decided with this type of methodology. For instance, this decision was decided based on the number of rooms in the apartment and how much of the physical space was affected by the problem at hand.
how is that presented to hearing officers? Is it just like a document, just like for this given petition, this is what happened? Or do you try to like aggregate them saying like these set of petitions involved rooms?
We're working on this particular document at this time.
Okay, so that's still
this is not a completed document. It's something that staff is working on.
Okay.
For the actual repository of decisions, they have an online repository of decisions that they can access with a matrix that goes into detail about what the primary topics of that decision is, and a whole bunch of other information in this matrix, and then they can search for potentially relevant decisions.
Okay, so if we do choose to move forward like option 2, let's say, so the analysis would be a starting point of that work, correct? Like we'll use the analysis that staff is working on as potentially maybe converting some into a regulation. Is it not?
And that and probably a lot of research into what other jurisdictions are currently doing.
Okay, thank you.
Committee Member Balch.
Thank you very much. This is a really important area. I am in favor of transparency, and both for the public, for tenants who this represents their home, and for landlords who represents their livelihood. So transparency is super important to me. A few questions. Thank you for looking at all the different jurisdictions. That's super helpful to know what other jurisdictions are doing. And you noted on slide 42 that these appear to be quite old, from the 1980s, and that recently adopted regulations do not seem to have these methodologies. I'm just curious if you have any sense of why. Did you speak to any representatives from those local jurisdictions to get some qualitative feedback on why they have not been doing that more recently than the 80s?
We have not reached out to the other jurisdictions yet. We were planning to do that should the RHC request additional insight into this policy area. Karen or Naz, do you have any insight?
Not in particular, but if you look, so the jurisdictions that have guidelines, the specific dollar amounts are the ones that date back to the 1980s. I do think if you look at those, you will probably see they're not that useful. And my guess is that hearing officers don't use them that much.
Okay. Thank you. On slide 43, the hearing officers seem to indicate that they would prefer access to the prior decisions. I would too, by the way. It's always helpful to know what has come before me. Obviously, they would have access to the Mountain View decisions. Are the decisions of hearing officers in other jurisdictions public record? Would those be accessible as well?
They'd have to put in a public records request for that.
Right, they're not. So they are public records, but most, I think I've checked a lot of the other jurisdictions, they do not make them readily available. You would have to submit a Public Records Act request to obtain those.
No,
so you need to know what you're looking for.
Got it. No data.
To
Okay.
ask for it.
Right. What's interesting also is that on that same slide, the last bullet talks about the concern that this might open up the process to more litigation. Though I wonder on the flip side, though, whether there's any precedent for that, because you could also say that without guidelines, things could appear arbitrary and so be more subject to litigation. So I'm just curious, is there any information on whether these methodologies have more or less litigation than the average?
We can only go based on reported decisions, which usually means those are decisions that go to the Court of Appeal. I'm not aware, maybe Naz is, of any decisions that specifically address this issue in California.
Okay. Let's see. Yeah, so option number 2, the only downside seems, so option number 2 being that to put in place methodologies. The main con that I'm perceiving is that it's just work, which, yes, but there don't seem to be any systemic cons beyond just the fact that it's going to take time for staff. Is that a fair perception, or are there other cons that I'm not being fair to acknowledge? Yes.
And I'm looking to legal counsel for that answer.
Was that a legal question?
I think it is primarily an issue of staff time, but it's also an issue of getting the right formula for the methodologies and what that really looks like, and is it going to noticeably enhance the hearing process?
Okay, thank you. That's important. Okay, and then my final question is regarding the valuations. It seems to me like whenever you're dealing with monetary amounts, you get into issues of inflation adjustments, you get into technologies changing or practices changing, so frequent, maybe annual updates. I'm curious, has that surfaced in terms of what would be the maintenance burden if there are valuations at play to just deal with the normal economic changes that occur over time?
Two things. One, I will also pull up the what these schedules look like so that you all can take a look at them really quickly. I think that might be helpful. Recently, very recently, I believe 2 of the 3 jurisdictions adopted regulation updates that now account for increases in the valuation schedules to automatically occur, and they are based on the whatever they call the annual general adjustment of rent. So that is, however, that is new. I'm going to go ahead and also show here what these guidelines look like. This was provided to the committee in the attachment, but it's a lot easier to just take a look at it really quickly. So here you have the city of LA. This is what they have in their guidelines table. It primarily looks at like a reduction in housing services, not necessarily habitability violations. And they are, as we mentioned before, rather broad. They don't provide any definitions as to what these things mean for the most part. You can see, there's nothing here about a hole in a roof or plumbing, for instance. Now, when we take a look at another jurisdiction that has actual guidelines, we go down to Santa Monica here. Skipping over these other ones. So Santa Monica has, again, a schedule of a guideline here, what they call valuation guidelines, and it gives you more information as to what that is. But as you can see, the ranges are quite extreme, right? So $18 to $228 a month, $18 to $455 a month. And there's not really a lot of definition as to why those amounts exist or what caused them to be determined. There's, as we mentioned before, there's no industry standard for this. You can see here again, these ones are, these are their reductions based on loss of services. So we have $36 to $750 a month. And then you go down to look at Santa Monica. Oh, and here's this one is, this is still Santa Monica, excuse me, we're looking at Santa Monica. Santa Monica also has a specific petition for habitability issues related to construction on site. And they give a percentage of rent in their second valuation guidelines. And this is just, and then also dollar amount decreases depending on what the issue is. But those are only related to petitions filed for construction activities on site. And then we take a look at West Hollywood, and similar to Santa Monica and LA, there's an issue, and then the low valuation and the high valuation. There's, again, not much of a definition as to why these are set at this amount, why they were chosen, but you can see it varies greatly. And so not only does the content vary between jurisdictions, but the actual valuation varies greatly between jurisdictions.
Thank you so much. That's very helpful. Thank you for your work.
Okay. I'm going to ask Committee Vice Chair Rosas to go next. To be honest, I forgot my question. I was so intently listening to everyone else's questions. I will remember it. Thank you.
Thank you, Chair. So it's interesting how each committee member has different perspectives, but as all of you know, I'm always worried about the workloads. So you did mention, I forgot the slide. I'm not as articulate as my fellow committee members. But can you tell me, in your view, how do you see the workload being fixed? I mean, as I see right now, you already did a whole bunch of work, and I'm pretty sure it took a long, long time. And then another concurrent question is, do you see any issues with the union? Because every time you add workloads, and you are represented by union, so do you see any pushback or issues with that?
To answer the first question, the reason why these regulations would not, and additional research would not be brought back to the committee until early 2025 at the earliest is due to staff workload. So we're hoping to smooth out the impact of this research by having that additional time to work on this research and regulations. As for who's performing the work, your legal counsel and senior management analyst are performing this work, the bulk of it. So as a salaried employee, it doesn't affect that in that way.
Okay, so it would not be the members. So this would be more a management's role?
It's me. Yeah.
Sounds good. Oh yeah, all right. Okay, thank you.
Having remembered my questions, is the repository of previous hearings available now?
It is available for hearing officers.
Okay.
And has been for about a year. Although before that, they could request relevant decisions.
Thank you. And as a evaluation, in a sense, of the current status quo, do you know, have our hearing decisions or our appeal decisions been taken to court?
No. We have one hearing decision that was challenged with a writ petition that the parties have been trying to settle that, so it has not really proceeded in court other than the complaint being filed.
So just the one? Wow.
And that did not affect any of these issues. So
okay.
It's not related to valuation.
Thank you. Committee Member Cox.
Yeah, just a few questions. I want to understand clearly here. So when you talk about methodologies and you talk about the evaluations, it sounded to me like you're saying that these are just suggestions to the hearing officer. They're not really going to be bound by them. Is that right?
That's correct for both instances.
Okay. And another question is, we talked about the idea of making previous decisions that would be related to a particular case available to the hearing officer. Is there any way to make that information available to the RHC members?
We can, although that would be a significant impact on staff time because we would have to go through and redact every decision.
Okay. And then the third question with regard to staff time is, can you tell me what work that you're doing that would need to be delayed if you were to proceed with this? Because I think it's never a question of, yeah, of course it's more staff time, but, you know, I mean, just to give an example, like the council always, like last night, they have to weigh decisions about what comes first and, you know, in terms of priorities. But, you know, I'm not aware right now of, you know, pressing issues that need to be dealt with.
We have the RUBS related utilities petition process,
Okay,
which will be being released this at the beginning of Q1 and of the new fiscal year, and then all of the petitions that will then be filed and need to be determined by staff. It's an incredibly significant impact. That alone is an incredibly
Okay.
significant impact to staff that we are struggling with and will very much struggle with in the coming months.
okay, that's fair. Those are my questions. Thank you.
Committee Member Ma.
Thank you, Chair. A thing I remembered is one of the pros was about clarification to petitioners, because one of the portions of the petition is figuring out what the tenant thinks they should be owed in rent. Given we don't have any methodology written right now, when a tenant comes to the housing help center and asks, you know, I need help filling out this form because I don't know the number, what kind of advice does staff give on that currently, if any?
So we can't provide legal assistance or legal advice. We can only provide information. And so typically what staff presents to petitioners is that they should consider the different area, how many rooms are in the unit, the potential percentage that the unit that is affected by the issue. Give them insights into, you know, different percentages that they could use. And then because they're the petitioner and they can put what they determine to be appropriate to them in the petition, they then determine what amount they put in the petition as their valuation.
Okay, so there's like an ad hoc informal methodology, but like it's basically just whatever you think from your head from like a high level advice, so.
Right, that's
Okay.
correct. We're not able to provide legal guidance or tell them what to put in the petition. And ultimately, it's not what they put in the petition is not while the hearing officer takes it into consideration, it's not what the hearing officer is making the determination off of.
Yep, okay, thank you.
Do you have a further question, Committee Member Cox?
The only question I have is, why do I have to press it 5 times to withdraw from being a speaker?
I think we're ready to go to public comment. So we do not have anyone in the room. Do we have online speakers who are raising hand who would like to speak to this?
There are no speakers online.
So I think we're ready to come back for deliberation. And after, you know, we may have further comments first, but is this a good, are straw polls going to be a good way to give feedback on this?
Yes.
Okay. Committee Member Cox.
Okay, thank you. You know, the reason why asking to have this study session, I thought it was a good thing, is because, I mean, there's a couple things as I've gone through looking at these, you know, appeal documents, particularly the ones that have to do with habitability, is that what I haven't seen is, you know, at least in the staff report, I mean, I could have missed it in the, you know, volume of the attachments if it was in there, okay? But in the staff report, what I'm seeing is, you know, the hearing officer will say, well, I assessed this amount, okay, for this particular reason, okay? But what I don't see is a rationale for, you know, at least behind that. Like, if they gave a paragraph about what they did, I would have really liked to seen a paragraph for the justification or at least the reasoning behind it, so that, you know, like when we're trying to weigh, you know, whether the hearing officer's decision is supported by substantial evidence, that would be very helpful to me. And that's what bothered me, is that I don't see that. So, I mean, you know, and even in this report, what I'm seeing mostly about is, you know, suggestive information to help the hearing officer in making his or her decision. But I'm not seeing the transparency back to the RHC members about why the hearing officers, or what their reasoning was in coming up about their decision. And that's really what I want to get at, you know, not just advising the hearing officers. Okay, so yeah, I mean, another question, yeah, and because, you know, I don't see the reasoning, I don't know anything about whether, or the past decisions, I don't know anything about whether these evaluations and decisions are being made in any kind of uniform basis, whether a precedent is being consulted, and those things would make me more comfortable that the right kinds of evaluations are being made. I mean, you know, what worries me is, like, you know, watching these legal shows on TV and you hear comments like, oh, we don't want to pull that judge, you know, she's a hanging judge, you know. And what I don't like to see in the idea is that, you know, like maybe there are hearing officers out there that some are really strict with respect to tenants, some are strict with respect to landlords. I want to have something that's uniform and that people can widely perceive and understand that's fair, and that we can too. So, so in the particulars, I guess I would say, so yeah, I don't favor option one, or I wouldn't have asked for this to come forward. And as for option two, I think that, you know, there's substantial, you know, evidence in the research that you've done that most jurisdictions that have rent control have at least some methodologies. And so it doesn't seem to me it should be an onerous amount of work for you to look at what they've done and come up with the best of it and make a suggestion for us to review. So, I mean, I'm in favor of that. When it comes to the option three, which is, you know, the evaluations, I do agree that the ranges that are out there, they really are, you know, kind of ridiculous, okay, in terms of how they've been set. They were set too long ago. They're set in dollar amounts, and I'm going to echo Committee Member Balch when, I mean, you know, what I really would like to see is for things that are perceived to be things that we think are going to be recurrent on habitability, that we first get some kind of idea of what the market value is, okay? And then, you know, like you could put a range on it for the severity of the issue, okay? But I mean, there ought to be some basis in market value facts when it comes to this stuff, and I don't see any relationship there now. So that's why I feel more confident looking at the methodologies from other cities than I do looking at this evaluation thing. And I think if we do the evaluation thing, I think we should do it right. So yeah, there's that. And then the other thing is, so yeah, I mean, you know, if we're going to come up with dollar amounts, they need to be indexed by inflation, and we have the AGA, and that can be done. So I would do that. But I like the ideas of a percentage of rent because you know, like, okay, the violation for a 3-bedroom apartment with a condition isn't the same as a studio, and to have one range from that in dollar amounts, that just doesn't make any sense. But I also, what I do like also is, I like these ideas for severe things that, you know, no less than 10%, and for a repeat violation, a penalty, like, you know, no less than 20%, because I think that's on the mark. You know, I think we've seen cases where, you know, there are landlords who, you know, they're just not really responsive to, you know, these concerns as much as some others. And so, I mean, you know, we need to have a way to show that that can be acted on. So anyway, those are my questions. And so I guess the high level thing is I favor some kind of option 2, option 3 if it can be done in a sensible way, not like it was done in other cities. And I want transparency for the RHC members in terms of, that's the thing I want the most, for how the hearing officers came to their conclusions.
Committee Member Brown.
Oh, I'm so excited. We finally have something we disagree on. Okay. So, yeah, when I read the report, I was very happy to see that staff has already been proactive at addressing the request from hearing officers to have a record that's searchable and indexed, that has a matrix for what happened and how the decision was made. That's what I would want, is to be able to consult previous decisions and say, you know, there's a leak. Find me the things that had leaks before. What was the impact? I can then look at the record. In the hearing officer decision, there were multiple paragraphs explaining for each one what the valuation was and why. They usually do go in depth into like how they calculate the numbers, and it is often a percentage of or a thing, and then they sum it to see what the actual result is. So I actually favor option one. I think that what we're doing is good. I like that we are providing the tools that the hearing officers have actually asked for, and to do their job and to use their judgment. I would like transparency. I would like to be able to access that in a way that is maybe, if not the full record with full redactions, then at least the aggregate. So the matrix level of for a given type of violation. I don't know if this could be something we could have in the report or just accessible, but the types of hearings that have been decided with any kind of adjustments and what those are, I don't know if that would be more or less work if we're already indexing it. Because I know redacting all the documents would be a lot. So yeah, I personally think that if we are doing the things that are working for the hearing officers, I would favor that instead of adding complexity. And I appreciate your optimism to think that there are not silly numbers, that there are numbers that someone else wouldn't come in and say, these are I mean, I'm sure the people who came up with the $18 to $455 thought at the time that was a very elegant solution for that thing, and that they were avoiding something ridiculous. And then later on, you're like, oh no, that's a guideline that isn't helpful. So yeah, that's my view.
Committee Member Balch.
Yes, thank you. Good points raised by the other two committee members. So on the slide and in the staff discussion, the hearing officers did say that they thought it could be helpful. I think it is important to listen to the people who are in the seat, who are doing the job, and provide guidance. I value guidance when I do work. And I think we all benefit from that. I think the transparency points that have been raised are really important, again, not just for the committee, but for the community at large and for tenants and landlords. This is a big deal for all people involved. I definitely agree with the desire for reasoning. I personally believe that having a methodology facilitates that understanding of reasoning. And I think, to your point, if we read the decisions, so to speak, we can see that today, but having the methodology would make that more consistent by having consistent language or consistent reference points. So to me, option two is a ideal place to be because it provides a methodology that you can build reasoning around and build transparency around. But I think the valuation is just going to be extremely difficult to be useful. I'm not surprised to see the order of magnitude or more than order of magnitude ranges, because a plumbing problem can be a loose washer. It could be a new sewer line. I mean, plumbing, all these issues are so very broad. It's really, really hard to come up with accurate numbers. You need specific professional analysis of what's actually going on. What I would say is that I would want to say, if I could wave the magic wand, let's start with the option two, and then down the road, we could always come back and add an option three, which has the valuations. We don't have to make it all in concrete right now. We can get started, and then let's see how it goes after a year or two, and if the hearing officers and the community feel that they would benefit from numbers, then we can provide the numbers down the road. But I think just providing the methodology would be a huge step forward for the process. Thank you.
Vice Chair Rosas.
Thank you, Chair. So I like Committee Member Brown. I would favor option 1. I'm not happy with option 2. I think it's too cumbersome. I am reassured that the hearing officers, even before we came to this meeting, they're already asking for what are previous decisions in previous cases. I think that makes me reassured that our hearing officers are doing a good job. They're looking at cases with a understanding and unbiased situation. If we start looking, I think our job is to make sure that the hearing officers that are hired, I think that's where our job is. Our job is to make sure that the hearing officers have great credentials, and when they come to us, that we feel confident in their decision making. If we start looking at every little step and decision that they make, I don't know if that will make them to have the liberty to use their experience, abilities, and knowledge to really focus on an unbiased decision making, because I think now they're going to have the RHC on them, and I don't think that is fruitful for everybody. And I really like the fact that we have also the option to really hear the tenants and the landlords, so that we can come and hear what their point of view is, and then we have the option to say, no, I didn't agree with the hearing officer for A, B, and C reason. But I think I would favor more option 1 because of those reasons, because I think allow people to do their job, and they will do great. If it becomes a process of micromanaging, it doesn't help anyone. Although I don't think we're there, but it might get there. So I haven't seen anything so far. So why reinvent the wheel? I don't know. You tell me. I would prefer option 1.
Thank you. Committee Member Cox.
Yeah, so then I have a question back for staff, because so what I learned about hearing officers is only that they are either lawyers or retired judges. And do they actually have the knowledge to evaluate how much should be charged for a plumbing problem? And if they're not experts or in like the costs of running apartment complexes or something, how do they get their information so that we know that they're making a fair evaluation if they have no guidelines at all?
Patricia may have something to add, but I would say most of your hearing officers are very experienced. They have experience both in Mountain View and in other rent-controlled jurisdictions. A lot of them also do other types of administrative hearings in the real estate context, so they have a fair amount of background on the real estate field. So they're relying a lot on their experience and their knowledge of the rental property industry.
Okay, so then it's probably fair that, I mean, they're hired in an interview process, right? And so then during the interview, you'll ask them, you know, how they acquired the knowledge that they need to be able to make these kinds of decisions and evaluations, right?
Right. They also have an opportunity in the hearing itself to request information from both parties that will help them make their decision.
Okay, I'm feeling better about it now. At least about whether we need to do number 3. But yeah, I'm still at least holding out for number 2 because I don't think it should be an inordinate amount of work.
So I'm going to share my response to one of your immediate comments, Committee Member Cox, which is that the hearing officer's job in valuing the loss of service or habitability is not to understand what it'll take to fix it. It's to set a value on the tenant experience of what loss of service is there. And so I think, that's a more widespread set of reasoning that doesn't require that deep industry knowledge, although there's certainly no harm in, there's benefit, of course, in having that, but you still don't need to know how you're going to make the hot water be there or the plumbing work right or whatever. So I walked in tonight thinking, gee, I'm pretty happy with option 1. And the only thing that's making me somewhat curious about some flavor of option 2 is the transparency, desirability. And one thing that I'm not wanting to do is option 3, because if you set numbers, they go out of date, and if you, it's okay. If you, and then if you apply an AGA to them. But I think that most methodologies are going to be saying what % of rent. And the rents go up by the AGA or by the market rate when new people move in. So I think we can let go of any set dollar amounts and go with methodologies, and that'll add some simplicity to this. So I'm wondering if we can do a straw poll now to say, let's pass on not option 3. Okay, in other words, let's not do a dollar amount grid. So does anyone have questions about this proposed straw poll? Okay, so how do we vote? Do we vote with Granicus or just by raising our hands?
I think we can raise our hands.
Yeah.
Okay.
Exactly.
So no dollar amount grid. Okay, we're in agreement.
Right. And that was in favor of no dollar amount unanimously.
So essentially, if I understand it correctly, is nobody is interested in option 3.
I would agree with that. So then I'd like to share some thoughts about 1 versus 2. So I'm pretty satisfied with what I've seen, and the only reason I've seen appeal, or rather hearing officer decisions, is because of the appeals. Because every time we get an appeal, we get to read up on speak closer to the mic. We get to hear one hearing officer's rationale. And, I haven't really been reading them all thinking exactly what, spreadsheet they had that said what % of this or that. And this last one will be interesting because I was a little taken aback by it because there were so many different pieces that were being, $50 for this, $100 for this. So there were multiple different rent reasons for amending the rent in that one. But overall, I have not had a sense of, gee, I don't know where they're getting this. I've had a good sense of this sounds reasonable, and I hear some arguments for it. So I'm interested in the grid that's being developed, along with to describe the aspects. Which ones were about plumbing, which ones were about mold, which ones were about, loss of parking. Patricia, am I getting, the gist of the grid you're developing correct that describes the matrix, okay, grid that's in, in the of the hearing decisions that are in the repository. Am I getting the general sense of it?
It's not quite that detailed yet.
Well, I didn't.
It provides the general, the general type of petition, what, so for instance, is it a petition, an unlawful rent petition? Are there concessions related in that petition? Is it related to a rent rollback? For habitability and maintenance, is it a habitability petition, or is it a housing service petition, or is it a combination of both? So it provides that level of detail, and that's what we currently have. And then we're developing the more detailed analysis of the past decisions where we can include more information like what you're requesting. They're two separate things.
Okay. So I think a way, a possible way for us to consider option 2 in the future would be to review the past decisions and to, have dollar amounts in that grid. And then, it may need to limit only to certain petitions, certain petitions, certain decisions that are less complicated, or some of the ones that are more complicated, you may need to make assumptions to tease out how much was for plumbing and how much was for something else. But I would like to not go all the way to a methodology, but with no rush, ask staff to bring us back that grid with dollar amounts and exactly what that would look like. But, as a starting place to see how much consistency there is between different decisions, I'd like to look at it, have a review of history first, and then I would be willing to consider option 2. So I guess
for a little bit more clarification, what staff is currently developing will have what type of methodology was used. For instance, was it a percentage of the living space, or was it based on a percentage of the number of rooms in the unit? Was it based upon the quiet enjoyment of the unit? How was was there impact to health and mental health that was considered? It may not always fall under a dollar determination that makes sense without the methodology, but we can provide both if that would be something that you would like to see.
Thank you. I mean, just hearing all those possible options, and if it's related to floor space and how much is usable and some becomes unusable, that sounds so mathematical. But quiet enjoyment is harder to measure. And so I think what's our next straw poll? So perhaps, we have more speakers. I will stop speaking. Thank you. Committee Member Balch.
Yeah, thank you. Actually, I was going to say something, but then Patricia kind of made the point, so I want to echo what you said, Patricia, or what I heard, is that methodology does not necessarily have to have numbers, right? So we don't have to go as far as trying to figure out, is a particular defect worth $10 or 10%? It really can be as straightforward or as basic as what some of the things Patricia said. What are some of the criteria? Is the person losing a parking space one day a week? Are they losing air conditioning? Do they have intermittent hot water? There can be qualitative, like almost a checkbox or a set of qualitative items that can provide guidance on what are some of the key considerations that go into a tenant's enjoyment of the residence, so that we and the whole community around us can trace the reasoning. Oh, I see. They didn't have the ability to take a shower. They didn't have this ability or that ability. So when I think of option number 2, that's what goes through my mind, is just more of the qualitative benefits or lack of benefits that are available in a residence to help guide the reasoning through a decision process. Thank you.
So I'd like to jump in just with clarifying question on that, maybe to you or to Patricia. So in the grid or matrix that you're developing, would it say the percent decrease, the percent of rent that the decrease was?
It could, depending on what the decision was decided upon. Not every petition is decided with that in mind. We could go back and do the math, but that may or may not be how the award was determined.
Perhaps I could just add, could I add something? We could decide that. We could basically say, we don't really think there's going to be value in trying to make a number. Let's just describe the criteria that the hearing officers might choose to use as a guideline.
That's exactly what the more detailed methodologies option is. Yeah. Right. So, and in other jurisdictions, again, this is something that, and we can provide more analysis on this if the committee decides to look more closely at option 2. Chair Keating, the matrix that we're currently making is for hearing officers for their specific use. The analysis that would be being done for policy consideration for the RHC for option 2 would look at other jurisdictions more intensely and go into what kind of information they provide in their more detailed methodologies. Some jurisdictions have very detailed methodologies for the hearing officers to consider when making their decisions that also spell out, similar to how ours do, but with more detail, what the hearing officers need to include in their decisions. So, you can definitely consider something like that, and we can provide more information on what those other jurisdictions do and what they look like in the next study session, should this come back to the RHC. Hopefully that helps clarify. The other item is being currently worked on by staff, which is the analysis for the hearing officers of what the prior decisions held.
Committee Member Cox.
Yeah, so I heard what Alex had to say. And I think there is a fundamental difference of opinion between his view and my view in terms of whether we as RHC members are getting enough information on the hearing officer's reasoning in setting amounts, and so, I get it that in certain cases, like for instance, where, there was mold in the room and I know how many square feet is the room. And so I can figure out what percentage of that living space wasn't available because of the mold, and therefore I can deduct 30%. Okay, that I get, okay? But most of the other things I've just heard seeing dollar amounts, and I don't know whether they're based on consulting, previous cases and seeing what were used, or, what any other reasoning was used. And I would feel more comfortable instead of just, $150 because, and one line, and that's what for me is missing. So I guess what I would like to know is, and that's more important to me, on whether or not the hearing officers are well enough educated to make their decisions. And so I would like you to poll the other committee members to see whether or not they think the information is sufficient, or it would be better to have more.
So is your request for staff's clarification, is your request for a straw poll to see if the committee would like option 1 or option 2?
No, this wasn't covered in the options. The options have only to do with methodology and valuations to be provided for the hearing officers. I'm talking about information about hearing officers' decisions that can be provided to us. And I don't know, maybe that's beyond the scope of the study session. But I mean, that was originally what I was hoping for when I raised the issue. So you can tell me whether it's beyond the scope or if we can take a poll. Or maybe it's useful to take a poll to know that we would have another study session. But I just want to know where people feel. And then, I mean, if people agree more with Alex than they do with me, I can accept that. But at least it's been asked.
If I could interject, I mean, I think what you're trying to determine is whether your fellow committee members agree with you that there isn't enough information in the decisions you're getting, and essentially agree with we need option 2 because we're not getting enough
but I mean,
information.
that's specifically what I want.
So maybe a poll on option 1 or option 2 would get to that.
If we have the poll on option 1 and option 2 first, and it comes out option 1, I think I have my answer.
I'd like to go to Committee Member Brown, if that's okay, and then I'll come back to you, Committee Member Rosas.
Okay. So I agree. I think a good structure for the hearing officer decisions, adding a bit of just here's the format, could be beneficial. I think that could be as easy as requesting that hearing officers add an extra sentence per aspect of the decision, just a memo instead of doing a full staff analysis of jurisdictions and methodology. I agree. I think that if we do that, we could just ask that hearing officers that they're people we can communicate. We can make our request known that for the benefit of the RHC in appeals, that it would be behoove us that they provide this structure, this amount for this reason. I would be fine with that, but I think that could be just, something like an email that we send to the hearing officers or Project Sentinel without having to tell staff, here's a huge project to go through to end up with a methodology that says, explain your reasoning, please.
I'd like to go to Vice Chair Rosas.
Thank you. So I'm struggling with trying to understand. When we get these decisions, we get all the facts. We can only decide on the facts that are on what we're told by the officer, by the tenants, by the landlord. I mean, for me, that is sufficient enough for me to get a good idea of what's happening. Because really what we're looking at is making sure that everybody's being treated fairly, right? I get that, and then that it goes to methodology. My concern is if we go into this rabbit hole, we're gonna waste valuable staff time, and we have not even finalized the RUBS. I know that probably for other committee members, RUBS is not an issue for you because you don't hear it out there in the community. I do. And I would like us to finalize that before we can have the staff work on another project. Maybe after. I have full faith in the hearing officers because I do have an understanding of the abilities that they have. And it's not ultimately per the hearing officers, they don't have the ultimate say. We do. And I think that by us getting the facts in the documents that we get, it takes away from how the hearing officer was feeling at the time. I think it's more relevant on this happened, so this is the result. I can understand that values are important, but I think what we are here to decide is, has the landlord treated the tenant right, and has the tenant brought a good case? If not, then the officer has the first say, the hearing officer has the first say with all their experience and knowledge. And then if the tenant and the landlord are still not happy with the decision, they come to us and they have a second go around. Maybe in the future I can think about getting a new process for the hearing officers. But right now, I really want to get this RUBS done and finalized before we can even think of anything else.
Committee Member Balch.
Yeah, it's a good discussion. I think that there are several things being conflated here that we need to keep distinct. This discussion or debate about explanations, I'm not sure it's the exact issue here. So I don't perceive it's about, I don't think that the hearing officers are not explaining themselves. It's not about explaining more, it's about understanding a consistent process that people use. And so if there's no consistent way to look at something, people can explain all day, but they may be speaking a different language. So I think it does come down to fairness, like Vice Chair Rose is saying, but fairness is in the eye of the beholder. We know that across society, a measure of fairness is hotly debated. If we all agreed on fairness, I think the country would be a magical harmony place. It's not. And so having a clear methodology is one way to express what is the aggregate view of the committee of what is a reasonable, fair way to evaluate these types of complex issues. One of the things I've been learning as I have observed the Rental Housing Committee, and now that I'm on it and helping to make these decisions with you all, is that while we have oversight, we have a very coarse hammer. It's almost a nuclear option. We basically have to choose between just letting it go or incurring a very expensive process to kind of redo. That level of that lack of granularity isn't exactly a way for us to kind of fine-tune things. We can only really account for what we consider to be really grievous miscarriages, which I haven't seen happen so far, but nonetheless, it is a very coarse hammer. And so having a sense for the community that there's transparency and that there's a clear methodology, that is, in my opinion, a really good way to try to have some more perception and reality of the consistency. The final thing, which I think I agree with you completely, Vice Chair, we have a sequencing issue. We have a finite amount of capacity with the staff. We can, if we believe that we want to have transparency and consistency, we can simultaneously agree on that and say, staff, finish RUBS, do what you got to do, and then you move on to this in sequence. No one is saying that you have to do all these things at the same time. No one's saying that this somehow takes precedence over RUBS. Do things in the order that they come in. RUBS came in first, get RUBS done. That's important to the community. Then we have the capacity, then we can do this next thing to ensure the long-term transparency and the consistency. So I think there are different issues here that aren't in conflict with each other. We can kind of take them in steps.
Committee Member Ma.
This is a question for staff. So in the analysis that staff is doing, what would happen? Is there any legal liability if we found out there were two cases that had very different methodology but involved the same rough outline of facts and situation?
No particular legal liability. Your decisions are not precedential with regard to each other. So it would be the same for every decision. Every decision can be taken up on a writ to Superior Court. And there's nothing that prevents a party from doing that regardless of the decision.
Yeah, and I guess a hypothetical that's aligned to that is, obviously everything we do is PRA-able. All the petitions, minus redaction of personal information, but you can still get the rough outlines. And if, say, there we get a future case where they PRA'd a past case and try to use that past case in the future case, saying this is what a previous decision was done. Would that have any impact on that future petition? Or is that just treated as the hearing officer's decision whether to do it or not?
I'm not sure I understand your example. If
someone tries to, cite a past petition about a similar situation, does it have any precedential?
So the hearing officer could consider it, but they're not
Okay.
required. Once again, the decisions are not precedential with regard to each other.
Thanks.
Committee Member Cox.
I'm sympathetic with what Committee Member Balch has said, that, we can take these things in order. If RUBS is so pressing that we can't do these concurrently, then, we can wait. I think it's better to wait than dismiss. Again, I do think that doing the methodology could be a worthwhile thing. I would encourage staff not to overthink it. I'm making a point that if we look, a majority of the jurisdictions do have some methodology and we don't. And so, there is some sense that in what others are doing, that it's worth considering. But again, getting back to what Alex's comment was last, even if we don't do that now, I think a note to the hearing officers that we, at least some of us, would appreciate, a little bit more detail and understanding their reasoning for setting certain amounts. It wouldn't cost any staff time at all, except to write that in a letter. And so I don't think that's something that we would have to wait on if a majority of committee members were in favor of it.
Committee Member Brown.
This is for council. If we do a methodology and guidelines, hearing officers are not bound or required to use it, right?
Well, that would be part of what you would have to consider if we were to draft regulations. But I think, as you saw from the staff report, in every other jurisdiction, the hearing officers are not bound.
Yeah. So we could come up with detailed methodologies that aren't necessarily used in a given case, which means that we cannot guarantee consistency. Not to say we shouldn't try, but in this case, I don't know that the work and the methodologies that we come up with outside of the process are actually going to aid hearing officers in doing their job in a way that is better for the outcomes of the cases or for us on appeal. I'm skeptical that it's going to be of value. In terms of transparency, though, Patricia, I think you're controlling. Can you pull up the most recent fiscal report that we had, page 2, the charts on the petitions? I wanted to kind of illustrate what I was thinking of.
This is interesting to see how we got to quiet. Alex asked a question and Patricia didn't say no. So we're assuming that she's pulling it up.
Yeah. Yeah. All right, so we have the rent adjustment petition section where we do break it down somewhat by category. And so in this case, this is information that we're giving to the public that we have about what's happening behind the scenes. I think this could be fleshed out if we are looking for transparency with what is happening in the city in regards to petitions for downward adjustment, that the habitability and housing services could be broken up into. This is the average, amount that is done, because it is public information, and I think that if we do it in aggregate, we're not doxing anyone, we're not releasing information that could be used to harm an individual, but we are trying to show what is happening in the city and what are we, the city doing to resolve these issues without going through the whole process. Like, this is already information we have. This is stuff that we are working on that is just a side effect of the stuff that we're already producing without having to go through and try to come up with procedures that tell someone how to do the job they're already doing in a way that is not binding to them, that they don't actually have to do, that they might not actually follow. Because different hearing officers have their, I'm sure have their own process that they've built up with over time across the various cities that they work in. That's my thought.
So I'm going to jump ahead of Committee Member Ma for just a moment. So what I'm hearing is, from Committee Member Cox is a request to hearing officers to say how you came to your conclusion. So that, again, because we don't know which decisions will be appealed, so we don't know which ones we would naturally see that come to us. But some of, if they're doing this for every hearing decision, just something brief, then, it would be ready. And then to Committee Member Brown's suggestion, I'm wondering if we want a form, just like a really quick form that, would say, those categories, so that the hearing officer themselves would check off, these are the categories, that this petition fell into. And then, the original rent and the amount of reduction, it would be coarse, but, because things have multiple reasons. But I'm just wondering if that would be a start, if there should be, if there's some form that we would like that would let us digest it quickly. And the form would be easy to make and fill out. Okay, Committee Member Ma.
This is a question to legal counsel. If we have an appeal, is there ever a time legal counsel would ever, flag to the RHC whether they personally or they, in their formal capacity, felt that the methodology presented in a hearing officer's decision was arbitrary or capricious?
Yes, we have done that in the past, and decisions have been remanded on the basis of determination that there wasn't sufficient evidence to support the decision.
What about methodology?
I'm not sure if I can recall a decision
but
where
that can
we've had
happen.
an issue with that. We do provide training for the hearing officers on a regular basis, and we do request that they explain their decisions, and we certainly will convey what is said here tonight to them in the next training. I don't know that there have been specific methodology issues, but if there were, we would suggest, if the decision was appealed, that that the RHC consider a remand.
Okay, so there is a process to catch particularly
Yes.
egregious cases if there's a situation.
Yes.
Thanks. The other question I have is perhaps more of a weird technical one is, do we dictate a format that the decision needs to look like?
No, I think, as you have probably noticed in the decisions that get appealed, each hearing officer seems to have their own format. We do, your regulations have some requirements that the decisions are supposed to make findings of fact and now apply the law and explain the reasoning behind the decision. We do review all the decisions. We do send them back to the hearing officers if we don't find that there's enough evidence, enough information for us to see how they made their decision.
Okay, thank you.
We do provide a general template for them to use should they so choose to do so.
So we don't have speakers. We need to figure out what we want to request and move ahead. So I'm hearing that, I don't think we even need to do a straw poll on this, and someone tell me if they disagree, but that RUBS comes first, and that in terms of priority, that evaluation schedule or methodology, not evaluation schedule, that a methodology or an assessment is secondary to RUBS. Committee Member Brown?
I don't think that's on the agenda item. Like the priority of RUBS is not part of the agenda item, so I don't know if is that something that we can.
I think, so the options that were presented to you were options 1, 2, and 3. If you went with option 2 or 3,
or other,
you were told, or do nothing. So if you went with option 2 or 3, as you saw in the staff recommendation, both of those would be deferred until we got through a lot of the RUBS issues. That's why they would not come back to you until sometime in 2025.
Okay.
Okay, can I propose a straw poll?
Please.
So all in favor of communicating to the hearing officers that we would like a structured justification for the monetary decisions in their decisions.
And that would be a paragraph.
Yeah, it'd be an email. And also maybe something in the training.
I think we would communicate that to the hearing officers as part of a training.
So, yeah,
But the result that you're asking for is a paragraph or, a short paragraph in the, or maybe, multiple comments.
I would accept a sentence or a bullet point.
Okay, but statements within the hearing decision.
Through the chair, Robert.
Okay. Anyway, yeah, that's what I'm asking for. I don't want to specify, you only need to write a sentence, but I mean, basically I'm thinking in terms of a paragraph of when we get the appeal decision, that information is in there about how they got to their conclusion on the dollar amounts. And we're requesting that. Okay.
I don't think you need to specify how long that explanation is. I think what you're asking for is for the hearing officers to explain their reasoning.
Yes, yes. Like my math teacher used to say, you don't get full credit if you don't show your work.
And then for us to provide that in our communication to you regarding the appeal.
Right. Are we online together?
Yes. Yeah. I don't want to be too prescriptive. Just I want to express our desires for information that we would then use in our decision making.
So I think this request is just for the hearing, to ask the hearing officers to be a little more descriptive and always be descriptive about how they came up with their dollar amount reductions and to put that into their hearing decision. Mm-hmm. Okay, I think we should do a straw poll.
Appeal. Yeah.
So. Would you like to speak to not raising your hand, Vice Chair Rosas? Or did you raise your hand?
No, I didn't raise my hand.
Would you like to speak to your different opinion?
No, why? You guys have decided, so I'm okay.
All right, thank you.
The RHC is in favor, 5 votes to 1.
Thank you. So now, for the future, for 2025, for coming up with more, some statement or that we'd call a methodology to advise things to consider when coming up with how the dollar amount of decisions. Are we interested in looking at that? Do we want to do option 2 in 2025?
Do you want to do a straw poll on that?
Do straw poll.
Okay, so I'm personally undecided, so I'm having troubles.
You can watch what the rest of us do, and then.
Okay, I'd be happy to do that. So, request staff to pursue option 2 is a straw poll.
I think that one failed.
I'd like to try, Committee Member Ma.
I'll just announce the straw poll results quickly.
It was 2 to 4.
2 to 4. Yeah.
So yes, I would like to explain my vote on that. So based on my question regarding tentative appeal decisions, right? Like obviously we do not see every petition that comes to staff. We only see ones where there has been some disagreement to the point where they want to come to us. And of the ones that have come to us, we have never really overturned a methodology. We note that there seems to be differences here and there, but then again, every case has intricacies that on rereading only becomes even more confusing. As a result, I do have trust in staff that, you know, if there were some really weird methodology that comes up, we'll be able to, you know, catch it. We'll be able to put it back to the hearing officer with the ability to, you know, re-examine evidence or just give direction like, this methodology looks just really weird. We want you to also consider these factors because they might be more reasonable, less arbitrary, basically. As well as, you know, I do look at the point of, you know, everything we do does have a staff impact. Everything we do needs to be monitored by bang for buck. And as of right now, whether we make that decision tonight or in 2025, it's basically moot. So if it does become an extreme case that we do need more clear guidelines, we can always do that in the future. And that's why for now, I'm going for option 1.
Thank you. Committee Vice Chair Rosas.
So I guess this is, I'm a little bit confused, I guess, now because, and it's not against anybody, it's just a process, right, that we have. So it's going to sound bad, but it has to be said. I don't know. Okay. So we have 5 voting members, right? And I don't know, this felt to me like this vote felt to me like now there's going to be a process and happening in 2025 where an official vote happened, right? No? Okay, so clarify that for me because that's how it felt.
As I understood, the straw poll, option 2 was rejected. And staff would take that as direction that you do not want us to come back with regulations on this issue.
Okay. Thank you for the clarity.
I would, Committee Member Ma, are you still more?
Yes. Does staff want a straw poll on whether we support option 1? Well, if we technically there's
by default.
There's
There's a 4.
There's an option 4, which is absolutely nothing. But does staff
or other?
Yeah. Does staff want actually a straw poll on that?
I have one more straw poll that would, I guess, be under 4 or. So before we go to option 1, I would be interested to have staff return. You know, I'm undecided if I'm kind of persuaded that we probably don't want a methodology, but I would like to hear a presentation in 2025 would be great on, say, 2 jurisdictions that have a well thought out, you know, that staff thinks is worth presenting that have a methodology. So after seeing what 2 other jurisdictions do around having a methodology, then I might want to reconsider. So I'm, let's have this fail. So this is a straw poll to say, I would like to just learn about 2 other jurisdictions. Fails. Thank you.
No. They've got questions in the queue on what you're saying.
Committee Member Cox.
Yeah, I didn't understand what you just said. So, I mean, the point of it is I looked at the staff report. They had analysis and information from a large number of jurisdictions. So what do you want beyond that? Or what is the straw horse you're setting up for us to burn? Okay? I mean, let's not be cute about it. Let's be clear.
Okay. So my reason for not just supporting option 2 is it sounds like a significant amount of work that will have a preference baked into it to do something with that work. And, to be thorough, if we chose option 2, I think staff would do significant research. And I don't think that's worthwhile, but I think it might be worthwhile to learn about, in more in depth about another valuation or another methodology that another jurisdiction uses. Right, and maybe not all of them, but I'm suggesting to learn about 2 of them, and staff could select.
Are you asking that staff would find out how these methodologies are used by examining decisions from other jurisdictions?
No.
May I?
I mean, I guess.
Because included in the staff report was the regulations from almost every other jurisdiction.
So that was it, what we saw in the, they aren't that long. Okay, so then, so it's what I read and around that was it. Okay, I withdraw my straw poll. Straw poll.
And given that option 2 and option 3 have been rejected, option 1 is essentially the status quo. I'm not sure you need to take a straw poll because staff is going to continue to do what we have been doing.
Okay. So are we done? Okay, well, yeah, correct, for this agenda item. Thank you. We now move to agenda item 7.1, adoption of annual general adjustment, the AGA of rent for 24-25. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card, but if you are here in the audience, no one is. And now we'll move to staff presentation.
I'm after
her. Agenda item 7.1 is a staff presentation regarding the adoption of the annual general adjustment of rent for 2024. And the purpose of this agenda item is to establish the allowed percentage of the annual general adjustment AGA of rent under the Community Stabilization and Fair Rent Act and the Mobile Home Rent Stabilization Ordinance for 2024-2025 of 2.4%. CSFRA section 1707 and MHRSO section 46.6 state that no later than June 30th each year, the RHC shall announce the amount of the annual general adjustment of rent, which shall be effective as of September 1st of that year. The annual general adjustment of rent is the percentage by which the rent for existing tenancies in covered rental units may be increased each year. This is only applicable to fully covered units. One increase can be given in a 12-month period, and the annual general adjustment of rent has a floor, so it's capped at 2% and has a ceiling of 5%, which means that it can never go below 2% and cannot go above 5%. To calculate the AGA, we utilize 100% of the Consumer Price Index, all items for the 12-month period ending in March. That's what's in the CSFRA. However, the CPI is only issued every 2 months. So the RHC had to decide between using February or April's index, and it chose February, which is released in March, which is why this confusion happened. The all items index used is the San Francisco Oakland Hayward index originally, which was then revised by the federal government and is now defined as the San Francisco area. So basically what we do is look at the consumer price index for the past year. So it starts in February of 2024, and then we look at the next one in February of, 2023, and then we look at the next one in 2024. And there's a difference that's calculated there and a percentage that's created, and it's 2.4% this for this time period. The AGA is effective from September 1st, 2024 onward, and property owners and landlords are required to provide a 30-day notice of the rent increase that's required under state law. The property must be in compliance with the CSFRA and MHRSO to give an increase. This means that they have to have registered their property. They have to have paid the annual rental housing fee or the space rent fee. They also have to be free of code violations, and the properties have to be in appropriate habitable conditions. They also have to have rolled back the rent if that was not complied with originally, and have provided appropriate rent increases in the past. If they are not in compliance with the CSFRA or the MHRSO, they are not able to lawfully give rent increases. They also need to provide a required information sheet that must be given with the start of a new tenancy, or in this case, with a rent increase. So the recommendation to the committee is to adopt a resolution announcing an annual general adjustment of rent under the CSFRA and the MHRSO for the 2024-2025 period of 2.4% to be read in title only and further reading. And that concludes staff presentation on this item.
Thank you. Are there any committee questions to staff? Okay. We have no public in the audience. Are there any online commenters?
No online comments.
Okay. So now we are back to, so we don't have questions for staff, so I think we're to deliberations. Is there a motion? We have moved by Committee Member Cox, seconded by Committee Member Brown. What do we read? Who speaks and who reads this?
I guess I get to read it. Can you put
Okay.
it up for me to read? How do I do that? Yellow button? Okay. So I make a motion to adopt a resolution of the Rental Housing Committee announcing an annual general adjustment of rent under the Community Stabilization and Fair Rent Act and Mobile Home Rent Stabilization Ordinance for 2024 to 25 of 2.4% to be read in title only, further reading waived. Attachment 1 to this memorandum.
I think, unless there were anyone who would like to comment, I think we're ready to vote.
Oops.
Vice Chair Rosas, I think yours might be blocked because you weren't on time. Can you read aloud your vote? Yes. Okay.
Yeah. Yes.
Thank you. Motion passes unanimously.
That was easy.
And one more from me this evening. Thank you, committee and Chair Keating. Agenda item 7.2 is the annual election of chairperson and vice chairperson for the Rental Housing Committee. And the purpose of this item is to nominate and elect one member of the Rental Housing Committee to serve as a chairperson and one member as vice chairperson for an annual term from May 2023 and 2024 until the end of April 2025. Little background on this, CSFRA Section 1709A provides that annually the committee shall elect one of its members to serve as chairperson. The first order of business for the Rental Housing Committee is to elect a chairperson. CSFRA Regulations Chapter 3 describe the roles and responsibilities of the chair and vice chair in more detail. The chair presides at all meetings of the RHC, signs written resolutions of the RHC, and meets with staff to set the agenda for RHC meetings. In the event of and during the absence or disability of the chair, the vice chair shall perform all duties of the chair and preside as chair at RHC meetings. The chairperson and vice chairperson are elected on an annual basis in April of each year, and the term for the chairperson and the vice chairperson runs from May of each year until the end of April of the following year. So the recommendation from staff is for the RHC to nominate and elect one member of the committee to serve as a chairperson and one member as vice chairperson for an annual term from May 2024 until the end of April 2025. And this concludes staff presentation.
Do we have any questions for staff? And do we have any one in the virtual audience who would like to speak to this item?
No speakers.
Okay, so now we are back to our deliberation. So we have a current vice chair, and are you interested in being nominated to become the chair?
As it was proven today, unfortunately, I am not interested in being the chair, although I will love to, because it is a very important, and I respect the chair position. And since I was late today, I would hate for me being the chair and because of my job, be late for this important meeting. But if I may, I would like to nominate one. So I would like to nominate Alex Brown as our next chair.
Do you accept?
Sure.
Okay. And so, so are we going to use Granicus to vote, or are we going to just?
Yeah, was there a second for that nomination?
Oh, there's a second. I second.
But the motion would be the election, the nomination.
The nomination effectively serves as a motion.
Yeah.
So I second.
You can't hit the button.
There can be other nominations, and then you can vote after all nominations. So if there are no further nominations, you could ask for the vote.
Did we want to, sorry, just for clarification, are we voting on the one nomination and then separately for the vice chair? Or
I was thinking to vote for chair first.
As chair, I think that's your decision, right?
Okay, but not for long, huh? So is this the right process that we ask for other nominations now before we vote on this nomination?
Yes.
Okay, are there other nominations for chair? I'm not seeing other speakers or someone, so I think we're ready to vote. So Andrea, we're going to vote online?
so if you can just press on your screen to move.
Can Guadalupe hit the button?
Can you hit the button?
I don't have a button.
Okay, I'll go ahead and do that for you.
So what do I say?
She'll do it for you.
Oh. Okay.
Okay, we'll just do Robert then.
I missed it.
Okay. So
I apologize. Can we just do a roll call for this one?
okay.
We'll start with Committee Member Brown,
Yes.
Committee Member Cox, Committee Member Ma,
Yes.
Vice Chair Rosas,
Yes.
Chair Keating.
Yes.
Motion passes unanimously.
Who's going to pay for the recount?
Congratulations. So now, do we have a nomination for vice chair?
Nomination for vice chair.
Who? Committee Member Brown.
Kevin, you want to be vice chair?
I accept the nomination, if that is a nomination.
If you assent to it, yeah.
Yes.
Okay. So now we need a seconder. So is
I
this,
second.
has this been cleared? Okay.
No, we'll just do it verbally. It's fine.
Yeah, because
Okay, we're second, okay. Mechanically can't vote, right. Okay. So I am seconding the nomination of Kevin Ma for vice chair.
Any additional nominations?
Okay, roll call.
All right, thank you. We'll begin with Committee Member Brown,
Yes.
Committee Member Cox,
Yes.
Committee Member Ma.
Yes.
Thank you. Vice Chair Rosas,
yay.
Chair Keating.
Yay.
Motion passes unanimously.
Congratulations to the chair, vice chair, if I'm allowed to say it.
Okay, so we are to item 8 and committee staff announcements and updates.
Thank you. All right, I will begin with agenda item 8.1, and we'll look at upcoming workshops and help center dates. The staff continues to hold virtual office hours every Tuesday from 10 a.m. to 12 p.m. People can join us on Zoom. And our upcoming workshops for the next month and a half or so, we have 2 workshops in April. So that's next Tuesday, one at 2 p.m. for landlords, and that will be virtual. And the other will be tenant focused, and it will be hybrid. And both of those will be focused on changes in utilities. So we'll start the conversation with the public about the changes in their utility billing. And then in the beginning of May 9th, we have a hybrid open to all workshop at 6:30, and we'll look at healthy and safe housing and what that means. And on May 16th at 2 p.m., we'll have a renter protection laws in Mountain View workshop, and this will be directed towards realtors and new owners to get them acquainted with their requirements under the rent protection laws. And we continue to hold our housing help centers. Again, we do have those split, so we have one focus for landlords, and that's the first and third Thursday of every month. So it's hybrid. We have it at our office at 298 Escuela and also on Zoom from 1 to 3 p.m., where landlords can come and get focused attention on rent stabilization and eviction protection. We help a lot with property registration and fee payments, compliance questions, and petitions. And also we have our housing and help center for tenants, which is the first and third Thursday of each month as well. However, this is in the evening from 6 to 8 p.m. Also hybrid at our offices, 298 Escuela, and on Zoom. And tenants can get information on housing programs, they can get eviction help, legal resources, and other sorts of supportive services like food distribution, diaper distribution, mediation services, and homelessness prevention resources. Any questions about upcoming workshops or help centers?
I have a question on the RUBS ones. Are the RUBS ones mainly targeted at we don't have them for new leases, or are we beginning to roll out, here is a preview of the process, be aware?
I think they'll be looking at information on, what landlords and what new tenants can expect underneath the utilities, and also looking at what's coming up in the future and how utilities will be needing to roll into rent. So it'll sort of be a more high-level informational workshop. And then as more information and more processes come out, there will be additional workshops and webinars that are planned for the community.
Okay, thank you.
We plan to do a pretty heavy outreach campaign on that.
So under committee comments, I wanted to ask the committee a general question. Tonight we had, I guess it's about how late we want our meetings to go. And do we have any appetite to split our meetings if we have a situation, for example, with 2 appeals and another agenda item, where we're pretty confident it would go quite late, as one of ours did. And so I think our option, and council may help me with getting the right words to this, is that we could plan to continue our meetings, to finish them on another night.
Yes, you can, you don't close your meeting, you adjourn to the next meeting, so it continues to be a regular meeting.
And so if we were going to look into this, I think the most compelling situation would be when there were 2 appeals, which we would hear in the regular meeting, because scheduling, you wouldn't want to, be asking people to come back on another evening. But are we interested to come back on another evening, or would we rather stay till midnight? I'm actually kind of neutral, but I'm curious we have speakers. Committee Member Cox.
Yeah, I guess the only one where I was, I wish there was, okay, I'm trying to find the right way to say this, but okay, last time we had an appeal, which was for 3 languages, and I think the result of that was it took 3 times as long. And I would like it if, when staff goes to schedule these things, that they take that into account. And if we're going to have one of these, just take the number of languages and multiply by that. And then don't try to have, too many things on that night if you're going to do that. So with the idea that if we get out of here by 11, I'm okay with it. Sometimes I can see that things might run over, but really I would like that taken into account. Like when I came here tonight, as I was going out the door, and my wife says to me, when are you going to be home? And I said, I have no idea. And the reason I said that is because I didn't know how many languages the appeal was in. Okay, but I want you guys, since you're going to be scheduling it, that, and I'd like you to take it into account.
Member Balch.
Yeah, that's a really good point. There's a dramatic difference whether there is interpreters and whether there's multiple interpreters. That was a real twist last time. Speaking of me personally, I need some kind of advance notice because I have work as well, and it would be. I don't know that I could guarantee that if we decided on the spur of the moment to continue, that I could just show up the next night. I might not be able to do that on 24 hours notice. I wonder if there's an option to start earlier if we have a large agenda, start at 6 instead of 7. So it would be easier for me personally, not saying anyone else, to start earlier if we knew we had a late agenda, so we would have a greater chance of finishing it in the same night versus having less than 24 hours notice to continue to the subsequent evening.
Council? Do we?
So If you were to continue the meeting, I did not assume it would be to the next night. It could potentially be the next week. Because we don't necessarily have the ability to have this room and have all the setup, but we would need to, so there would be some advance notice.
So I travel for my work periodically, so I try to make sure I'm not traveling on this day on this week.
Right.
So if we were interested in this, we'd probably have a backup night the following week. And it might not be Thursday because I think rental housing staff is pretty busy on Thursdays, we heard. So, let's see. So I think Committee Member Cox, do you have more to say or you already? Okay. Committee Member Brown?
So I'm broadly supportive of this. I think doing it 2 nights in a row sounds scary for other reasons. So I'm with you on that. I do support that when we have a long agenda or something is taking too long, being able to continue it to either the next meeting, in which case we, hopefully we have a light agenda that time, or a special meeting. We had this room on Mondays. I assume the room is sometimes available on Mondays, so that could be an option. Recognizing that could interfere with work schedules and that might be complicated, and hopefully as the next agenda item, knowing that in advance when we're going to have the meatier topics and things might get split, I think it's something we could ask staff to try to help us to understand in advance, maybe, hopefully.
Yeah, and staff does try to consider keeping the agendas reasonable. The one issue is sometimes with appeals, because we do want to deal with them expeditiously. So for instance, last month's meeting, we just happened to have 2. So we felt like we had to get through it. I would also note that staff did not know that we were going to have 2 different languages until shortly before the meeting.
Committee Member Rosas?
So if we are choosing, well, I'm just going to give my opinion if I may. I would prefer to have a separate date than start earlier, although this is a very busy time for me. But normally this happens like every other year. So normally, if you guys see my history, there were times that I was even here half an hour early. It's just that this time for me is a little bit difficult. So, but I foresee that for this year, I foresee that it's probably that I would prefer to start at 7 than to start earlier. I'm sorry if that is, and to extend it to another day. But if we can, I would prefer that.
Yeah, no, it's challenging. Calendars is the hardest thing. So I can just express my own personal situation, and people can take that or leave it. The least impactful thing for me, the easiest to comply with, would be a second day in the same week, because once there's a weekday night, that kills my travel for the entire week. I simply cannot X off half a month from my work schedule. That's not acceptable. I just wouldn't be able to participate. So, if it was like a Monday and a Thursday on the same week, or a Thursday and a Wednesday, that I could work out. That would just be the week that I would not travel. Yeah.
Committee Member Ma?
Okay, a few thoughts. One is, from a personal standpoint, I'm fine sticking to the very end, right? I don't think we've only had one meeting go after midnight, I'm pretty sure. I understand that's not really a sign of the future, but whatever. For the concerns about travel, I mean, the Brown Act teleconferencing is still an option, right? It's a little bit weird because you have to declare your address at that point, which perhaps if you're traveling is a little bit easier because that's an ephemeral address that most likely no one's going to show up physically to, but there's there. Yeah, that only happened once. But obviously, it's this tension between appeals need to get done because there are people who have things that who have material interests that needs to get resolved, as well as policy that, the earlier we get policy done, the earlier the effects come up. So, but I defer to the body because inherently we also need to be accommodating to make sure that we do have people who can sit through meetings like this.
Committee Member Cox.
Yeah, for me, I would like it. I mean, if we're going to continue to another time, I would rather continue to another Thursday because I'm involved in a lot of other organizations around here, and each one has their night. And I mean, if you plop on a different night, another one of these kind of meetings, you're going to slam on something else I'm doing almost for sure. So that's my view.
Is teleconferencing a possibility? And that's a question to staff and to Committee Member Balch.
There are options for teleconferencing. I think Committee Member Ma is correct. Under the Brown Act, there's the option to teleconference in. We do have to have a majority of the committee members in this room. If you are traveling, if you're willing to post the agenda where you're traveling, and we also have to know that address in advance because our agendas have to indicate that members will be attending from that remote location. There are also certain circumstances if somebody's ill or there's an emergency that don't require the posting of the agenda, but they do require other procedures.
Committee Member Balch, would it be possible? Go ahead.
My personal challenge is that my most common travel is to the East Coast, so I would be 3 hours ahead. So that would be difficult. Sorry.
So, Committee Member Brown suggested, Mondays for some of us are clear because we used to be part of the Rental Housing Committee meeting on Mondays. Robert, have your Mondays become full?
Yeah, I have two organizations that since we moved to Thursday are now competing for my Mondays. So that would make you would be 3 different places slamming on Mondays. So Mondays is the worst day you could choose. The other 2 are the Old Mountain View Neighborhood Association and the Mountain View Historical Association.
But only some Mondays, right?
It's some Mondays, but next Monday, those 2 are on the same day.
Oh, come on, big deal.
Committee Member Ma.
To clarify, our previous schedule, the Monday would have been the Monday of this week, correct? We can't really make a backup option being the day before our regular meeting unless we decide some kind of method saying if we have 4 appeals in a week, 4 appeals in a meeting, we put 2 in one day and 2 in the other. But yeah, just bringing that up.
Yeah, I think that I understand the concern. I think staff can take this all into consideration as we start considering future agendas, and if we see a need to have multiple meetings in a month, raise that with you all. So, I mean, we understand that there needs to be some limit on how long you're willing to sit here, and we do try to accommodate that. And we do adjust the agendas when we see that they're getting full.
Committee Member Cox, you're still in queue? Okay. Committee Member Ma.
This is just a procedure question. The question you're bringing up is technically a question for the chair of the next session, right? Unless you were requesting a regulation for the meeting, no?
That isn't actually on the agenda, so you cannot actually take an action.
Yes, it would
This
be
is just a discussion.
Discussion or potential referral.
Committee Member Brown.
Would there be any issues with the fact that we vote on our schedule annually for which meetings we have? That this is something we agendize and vote on for the meeting schedule, like our cadence? Would introducing special meetings be difficult? Or would we just have to vote on each of them ever? What would the announcement look like?
I'm not sure I understand the question.
In November, we usually vote on the next year's,
Right.
when the schedule is. And that's something that is a public thing that people can plan around, otherwise, and that we can plan around. So if we are going to introduce special meetings in advance on months that we know are going to be heavy because there are multiple appeals, how does that,
So we can request a special meeting, and staff can request that. Typically, what we would do is talk with the chair and then see if we could find a date that we could get a quorum for a special meeting and then call a special meeting.
and this doesn't have to happen at a public meeting? This can happen?
No.
Okay.
No,
Okay,
That's different
that was my
than the-
concern, is that would we have to, yeah.
it does not.
Okay, thank you.
And just to clarify, council, that is different than continuing a current meeting. Continuing a current meeting isn't considered a special meeting, correct?
That's correct.
Committee Member Ma.
And since you brought up the work plan, obviously the end half of our work plan this year is relatively light on discretionary, I guess, direction for regulations. So obviously, at the worst case, you can always punt a discretionary item to a later meeting at the cost of time, for obvious reasons.
Committee Member Rosas. Oh, sorry, I skipped. Go ahead.
I mean, why couldn't we just play it by ear? I'm sorry, because we've done it before, right?
Can we play it by ear?
Yeah, I mean, I think that's kind of what I'm suggesting is that as staff works through agendas and as appeals come up, we work with the chair and the vice chair to see if we think we need to call an additional meeting or potentially adjourn a regular meeting to another time.
Okay, Committee Member Cox.
Yeah, I'm not sure what playing it by ear means. I mean, if we get, I mean, I understand in general the concept, but what I want to know particularly is if we get to a meeting that we think is running too long, I mean, you know, and then we just kind of say, okay, we don't approve, we want to continue the meeting to another time. Do we need to all get our cell phones out and figure out what day is the right day to do that at that point?
So there are a couple options. If a meeting is running too long, and we have done this in the past, we have continued specific items to another meeting. And then those items just carry over to your next regular meeting. The other option is to try to adjourn the meeting to another time. And I'm just looking at your rules to make sure your rules do not require that the the rules are not specific, but I don't think it's required, and I would have to look at this, that if you adjourned, that you at that moment have to state the time, but obviously we would have to find a time that worked for a quorum.
Okay, but how would we do that then?
Well, when we've had to either call a special meeting, or you may recall that we had to reschedule a meeting, we just sent out emails to the RHC and asked if people were available for specific dates.
Well, at least we've all thought about this now. I don't think we have. Pardon, Patricia?
Oh, no, sorry.
Oh, Naz.
I was just going to suggest, I mean, I think as Karen is noting, we can probably work with the chair and the vice chair if we see that it's a particularly hefty agenda. We'll know that we usually meet with the chair and the vice chair beforehand to go over the agendas for the meetings. And so in that case, if we look at it and we say, hey, there's a possibility that this one is going to go over, then we could preemptively ask you for your availability should there be a need to continue the meeting. And that way we will have that ability, that on hand at that meeting, should it become necessary to continue the meeting.
Okay, are we done with this? Oh, Committee Member Rosas.
I just wanted to help committee member Cox that playing it by ear is just basically saying, hey, this is what's happening. Are you able to make it? And then if I am not that busy, I probably would be able to come earlier. And that has worked for me in the past. So if you just give me a little bit of notice, that's what playing it by ear means. So that's all.
And Chair, I believe you were going to go over agenda item 8.2.
Be to do that? Okay. So for our May meeting, we have appeal of a hearing officer decision and what's chapter 13? Oh, okay. And so we've passed regulations a while back. Can some of staff speak to what will be?
We need to make some adjustments in those regulations as we've started to implement the process.
Okay. And then CSFRA and MHRSO recommended budgets and financial expenditures reports for the ending year or through March. Okay. All right. Do we have anything else, anyone? Okay.
Wait, I want to thank you, Chair and Vice Chair.
Thank you. It's been a very rewarding experience.
I thank the new chair and vice chair for stepping up. I'm ready for a break. Thank you. Okay, this meeting is adjourned at 11:03. The next Rental Housing Committee meeting is scheduled to be held on Thursday, May 23 at 7 p.m. Thank you.